honorable members, shall we pray? Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that it may perform its high duty as in thy sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people may be well and truly served, and thy good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the efforts of those who struggle to make this vision a living reality. Inspire and strengthen our people, that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Honorable members, we take item 4, correction of votes and proceedings and official reports. We start with the correction of votes and proceedings of Monday, 11th December 2023. 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 8. Page 9. Page 10. Page 11. Page 12. Page 18. Page 14. Page 15. Yes, page 15.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, let me refer the House to motion number 10 on page 15. Mr. Speaker, if you take a look at line 4 of how the motion has been couched, throughout similar motions, we have used year instead of period. Mr. Speaker, particularly if you look at page 13, all the reference to the reports that we have referenced has been the use of the year ending 31st December. But if you come to motion number 10, decided to use for the period ended 31st December. And immediately after that, motion number 11, we've gone back to use for the year ended 31st December. So I think for the sake of consistency, we should be able to adopt just one, either a year or period, just for the sake of consistency. Thank you very much.
Yes, Honorable Member, thanks so much. The correct one is for the year, financial year, and not period. Yes, Honorable Member.
Speaker, with respect, I think my colleague is right. However, I have a copy of the report here. So if it is the decision, Speaker of the House, that we should adopt a consistent rendition, that'll be fine. But fact of the matter, the report captured is at period.
Yes, Honorable Members, the report misled the table office, and so it should be corrected from the report. We all listen to the minister. We have copies of the budget statement and economic policy for the financial year ended. That is how it's titled. Honorable Members, we move to page 16. Sorry?
Speaker, this is actually in respect of the public accounts reports that we adopted yesterday. So
Yes,
the rendition
yes.
should be consistent with the budget statement.
Exactly.
Yes. Thank you.
16. Honorable Members, the votes and proceedings of the 28th sitting, dated Monday, 11th December 2023, as corrected, are adopted as a true record of proceedings. Item 5. Item 5. Statements. Majority Chief Whip.
Speaker, as was agreed, we intend to start with the consideration of the proper human sexual rights and Ghanaian Family Values Bill 2021. And Speaker, it's on page 29. And so, Speaker, at the commencement of public business, there's a So may we move to page 29 to consider the proper human sexual rights and Ghanaian Family Values Bill 2021.
Yes, Minority Leader.
Mr. Speaker, as per the agreement we had, item 41, motion 41, page 29. I've had a conversation with the ranking and then the proposers of the bill. They are on their way. Okay, one of them is here and the rest are also coming. So we can start considering the motion on proper human sexual rights and Ghanaian Family Value Bill 2021. Thank you, Mr. Speaker.
Yes, honorable members, at the commencement of public business, item 41. Item 41, we will be dealing with the proper human sexual rights and Ghanaian Family Values Bill 2021 at the consideration stage. The proper human rights. Honorable members, we started this a few days ago, so we'll continue from clause 3. We have the chairman is not available, so any member. Where is the member? Clause 3. There are proposed amendments to the clause, and the first one stands in the name of Honorable Oseche Mensah Bonsu. Yes, please.
Speaker, seek your leave to move the present amendment standing in the name of the majority leader on his behalf. Yes, majority leader on his behalf.
You have his authority to do so?
Mr. Speaker, that is so.
Yes, you may do so.
Mr. Speaker, thank you. Mr. Speaker, amendment proposed, surplus 1, line 1, delete each and insert a. Mr. Speaker, the rationale simply is that in consonance with modern drafting, we decided, we agreed to insert the indefinite article a instead of each. Mr. Speaker, humbly move.
Yes, ranking member.
Mr. Speaker, I rise to support the amendment.
Motion moved and seconded is for the consideration of the House. Honorable members, I put the question. Those in favor of the proposed amendment, say aye. Aye. Those against, say no. Honorable members, the ayes have it. The motion is carried. We have a second one, proposed amendment standing in the name of the same Honorable Oseche Mensah Bonsu. Yes, you may do so on his behalf.
Speaker, thank you. Speaker, amendment proposed, surplus 2, paragraph C, delete and insert the following: religious instructor, a teacher, or any other educational instructor. Mr. Speaker, the present amendment is simply to do what we call syntax, internal structure of sentence, to rearrange the original rendition as contained in the bill. Presently, the rendition is to this effect: a teacher or any other educational or religious instructor. So the amendment presently being proposed is to rearrange that for the consideration of the House. Thank you very much, Mr. Speaker.
Honorable members, the motion is moved for the consideration of the House. In the absence of any consideration, I put the question. Those in favor of the proposed amendment say aye. Aye. Those against say no. Honorable members, the ayes have it. The motion is carried. We go to the third proposed amendment to the same clause, standing in the name of the same person, Oseche Mensah Bonsu.
Speaker,
I think he has proposed amendments to this clause throughout. So you have to stand to move them.
Very well.
Yeah.
Mr. Speaker, thank you very much. Mr. Speaker, clause 3, amendment proposed, surplus 2, paragraph D, delete and insert the following: a traditional institution, a church, a mosque, or any other traditional organization. Mr. Speaker, humbly proposed. Thank you.
Honorable members, motion moved is for the consideration of the House. I put the question. Those in favor of the proposed amendment say aye. Aye. Those against say no. Honorable members, the ayes have it. The motion is carried. We'll move on to the next proposed amendment.
Speaker, thank you very much. Speaker, clause 3, amendment proposed, sub-clause 3, opening phrase, delete collectively and insert variously. Mr. Speaker, humbly proposed. Thank you.
Honorable members, the mood is for the consideration of the House. Instead of them doing it together, each could on its own act without the rest. So that's why collectively is being deleted and we're inserting variously. Those in favor say aye. Aye. Those against say no. Honorable members, the ayes have it. The motion is carried. We'll move on to the next proposed amendment to clause 3.
Speaker, thank you very much. Speaker, clause 3, item number V, clause 3, amendment proposed, sub-clause 3, paragraph A, line 2, before integrated, insert preserved and afterlife, add through formal and informal education. Mr. Speaker, so that the new rendition will be to this effect. A person,
the institutions referred to in 2
yes,
shall variously ensure that.
Yes.
Or should I help you? Let me help you with that.
Okay.
So rightfully, right, Honourable Speaker, the new rendition will read: the institutions referred to in subsection 2 shall variously ensure that the proper human sexual rights and Ghanaian family values are preserved and integrated into the fabric of national life through formal and informal education. That is how it will read down.
Yes, Honorable Member, you should take note of the fact that earlier on we had moved a consequential amendment to delete the word proper.
Yes.
Yes, so take note of that. So it will read: the institutions referred to in subsection 2 shall variously ensure that the human rights, the human sexual rights and Ghanaian family values are preserved and integrated into the fabric of national life through formal and informal education. Those in favor say aye. Aye. Those against say no. The ayes have it. The motion is carried. Yes, we have another proposed amendment to clause 3.
Speaker, thank you very much. Item number 6, clause 3, amendment proposed, sub-clause 3, paragraph B, line 2, delete perspectives and insert dimensions. Humbly submitted, Mr. Speaker.
Yes, the last time we discussed this matter, so I will just put the question: delete perspective, insert dimensions. That is the word used in the Constitution. Those in favor say aye. Aye. Those against say no. Honorable members, the ayes have it. The motion is carried. I now put the question on the whole of clause 3. And the question is that clause 3 as variously amended stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable members, clause 3 as variously amended is ordered to stand part of the bill. Clause 4.
Prohibition against undermining proper human sexual rights and Ghanaian family values.
We have a proposed amendment standing in the name of the chairman of the committee. Yes, Chairman.
Mr. Speaker, the proposed amendment is to delete. That is item Roman number 7, clause 4. The proposal is to delete the entire clause, but it looks as if there is I have to refer to my notes, Mr. Speaker. The intention was to delete the entire clause and to insert another, but I don't see the insertion here. That's why I am reluctant. Mr. Speaker, because it's consideration, may we move on to the other amendments then, or the ranking member?
I want to listen to your ranking member, right. Yes.
Mr. Speaker, the committee proposed to delete clause 4 in its entirety for two reasons. One, if we look at Article 39 of the 1992 Constitution, the obligation created is without sanction. So we cannot be creating sanction here once we are making reference to the Article 39. That is why we read in its entirety. Because the Constitution that enjoins us to protect our cultural values is without sanction. So if we are making this particular law, we have to create sanction here. That is why we are proposing to have it deleted. The second reason is that the clause is full of ambiguities, with difficulty creating the offense. So, with these two reasons, we are of the view that the clause should be deleted in its entirety. Mr. Speaker, thank you for the opportunity.
Yes, Honorable Haruna Idisu.
Mr. Speaker, I have a difficulty accepting the ranking member's explanation. Mr. Speaker, if you recall, in one of the rulings of the Supreme Court, in the matter involving Chachichikata, the Supreme Court was explicit when they said that one, the offense must be clearly defined by legislation. What is considered a crime? Now he references Article 39. The Constitution is not to define offenses for every crime. It is not in the Constitution. That is why you have other enactments. So for the Constitution, rights are rights, freedoms are freedoms. If you want to create an offense, let this be expressly stated in the legislation. And I think that he should not rely on 39. He can give a more convincing reason. But to say that because in Article 39, there is no offense or crime, I don't think that is good enough. When you breach some of the rights and freedoms, where do you get the penal consequences of them? In other legislations. So, Mr. Speaker, he should come clear with a better convincing explanation. I thank you.
Chairman of the committee.
Mr. Speaker, I'm grateful to the ranking member. But in addition to that, the committee was of the opinion that there were so much subjectives and ambiguities which make it difficult to establish the offense. At least at the committee level, that was the conclusion. So the entire clause 4, the committee advised that it be deleted in its entirety. But I see that there are further amendments, and that was where my confusion lied. If there are any reasons why anybody would want us to not to delete that the amendment, we have proposed the amendment and it is moved, that we thought that it would be wise that we delete clause 4 in its entirety. Thank you, Mr. Speaker.
You want to come back again, ranking member? Yes, please.
Mr. Speaker, when I make reference to the Constitution, I said the obligation created does not make it an offense. But Mr. Speaker, let us together look at clause 4 carefully. The marginal note is prohibition against undermining proper human sexual rights, and Ghanaian family value. Now, clause 4.1, a person shall not undermine the human sexual rights and Ghanaian family value. Mr. Speaker, what do we mean by undermining? What would then constitute undermining? It is so subjective. Mr. Speaker, if you come to the second one, directly or indirectly instigate, command, counsel, procure, solicit, or, Mr. Speaker, what by instigate? What do we mean by command? Mr. Speaker, it's full of subjectivity and ambiguity. And in view of the fact that the Constitution creates the obligation there, all right, but in the wisdom of the framers of the Constitution, they deem it necessary to leave it at that particular level. Mr. Speaker, it is in this view that at the committee level, we are proposing that this particular clause be deleted.
Chairman.
Mr. Speaker, we wrote finally to the Attorney General, and this is the response that the Attorney General gave on this clause. And I quote verbatim. He came personally and discussed this with us. And this is what he had to say. Clause 4. Prohibition against undermining proper human sexual rights and Ghanaian family values. Though this clause creates an offense relating to undermining proper human sexual rights and Ghanaian family values, what constitutes, quote, undermine, end of quotation, is not defined, and therefore the basis of the offense cannot be determined. Mr. Speaker, this is the advice that the learned Attorney General gave to the committee, and the entire committee agreed on this advice. And that's why we agreed, as had been said by Ranking, that it was too much of subjectivity, and therefore we need to, and ambiguities, and that is why we are proposing that in deleting and in creating an offense, we shouldn't be having ambiguities and subjectivities. And that's why the proposal is that we delete the entire clause. Thank you, Mr. Speaker.
Speaker, thank you for the opportunity. Speaker, I disagree with the position of the committee at the committee level, and I will do so again on the floor. Mr. Speaker, 4, it's so cardinal to this legislation, so cardinal, so fundamental to it. I have been struggling to appreciate the point made by the ranking member that this offense, Article 39, is not been able to point it out. There's the subjectivity element that he points to. That too, I am struggling to appreciate, because you see, when we enact the provision this way, subject to the enhancement contained in the amendments listed thereafter, there will be investigations. If somebody makes a complaint that Clause 4, which subsequently will become Section 4 of the law, has been breached, that is not the end of it. Investigations will be conducted. It is the investigation that will establish that indeed Clause 4, subsequently Section 4 of the law has been breached or not. So there are similar provisions in other law that which creates the penal offense for which they are in existence. So if the ranking member and the chairman is of opinion that the use of undermine is nebulous, is subjective, is vague, is lacks clarity, what in their opinion will be the most clear diction to adopt? They have not been able to propose that. So being merely against the subsistence of this provision in the law is not sufficient. They should bring alternatives. Otherwise, then they should allow other members who have gone ahead to propose amendments to the provision which will make it better, so that those amendments can be considered and carried. Our task this morning is to see whether or not this provision can be considered subject to amendment, but to submit to the House that the entire provision be deleted because it offends Article 39 of the Constitution, which, in my opinion, has not been established. Sorry, I'm not putting words in your mouth. I'm making submission. So you resume your seat, Mr. Speaker. I recognize you. I am saying that you have not demonstrated that Article 39 has been breached as a result of this provision. You haven't established that, and that's not, Mr. Speaker. Furthermore, the advice from the Attorney General also merely suggested that it offends the Constitution. It's not been able to demonstrate how the use of undermine in this provision offends the constitutional provisions that he insinuated. And so it is based on these reasons that I opposed the amendment at the committee level. I stood against it. I was defeated. And the committee went ahead to suggest that it should be deleted. But I'm happy that I found support in the majority leader and the former minority leader that it's a provision that can be properly considered, subject to the amendments proposed and carried. Mr. Speaker, it will enhance the law.
Let me listen to Honorable Haruna Idrisu.
Mr. Speaker, thank you very much. Mr. Speaker, the clause we are looking at is at the heart of the bill. Now, if the word undermine is what is posing the difficulty, probably, Mr. Speaker, 4.1 can read, we substitute undermine for promote, and then change the language in the negative, so that to read that a person shall not promote improper. A person shall not promote improper. Then you are now defining it, because the difficulty is with the use of the word undermine. So we can reverse it. A person shall not promote improper human sexual rights and Ghanaian family values specified in Section 2 of this Act. So the word undermine will go, and probably it now can sit with the thinking or contemplation in Article 39 of the Constitution. I do not think that the emphasis that 39 should necessarily create an offense by the Constitution is the thinking of those who frame the Constitution. So maybe the word undermine is what is giving us a difficulty. We should delete the word undermine and go for a person shall not promote. Then in the negative, promote improper human sexual rights. Then Article 2 becomes relevant. I thank you, Mr. Speaker.
Yes, Chairman.
Mr. Speaker, I find the difficulty that my friend Roxanne is in this morning. He's wearing two hats. Mr. Speaker, he is one of the sponsors of this bill, and he is also a member of the committee. And I am presenting the committee's report. Now, I am not saying that if anything he doesn't agree with the committee report, he should not air his views. But at least at the committee level, that was the agreement, that because of the ambiguities and the uncertainties, subjectivity, we would be able to delete that clause and will still achieve our aim within the bill. So I still move that the entire clause be deleted. I so move, Mr. Speaker.
Yes, we listened to the motion moved by you, but there's a proposal now by Honorable Haruna Idrisu. Do you find that acceptable? Yes, ranking member.
Mr. Speaker, if you go to clause 12 of the bill, the marginal note alone cures the proposal being made by Honorable Haruna Idrisu. Prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act. So it means that prohibition is already, promotion is already as an offense. So if we do that particular amendment in clause 4, what will be the effect of that amendment on clause 12 of the bill, which also prohibits promotion? And Mr. Speaker, let me use the opportunity to state that I choose my words carefully. In arguing using Article 39, I never said it offends Article 39 or the provision breaches Article 39 as stated by my learned brother, Dafameko. What I stated was that looking at Article 39 of the Constitution, it doesn't create an offense. It creates the obligation without the offense. And clause 1, from clause 1 to clause 3, is functioning along Article 39 of the Constitution. Therefore, it is not necessary to create the offense here. Rightly speaking, Honorable Haruna Idrisu said we should change the word to promotion. Now, if we change it to promotion, that has already been taken care of by clause 12 of the bill. So do we create an offense of promotion and come to clause 12 and create the same offense of promotion? So thinking through the entire bill, the committee is of the view that clause 4 of the bill should be deleted.
Yes, Honorable Haruna.
Well, Speaker, having listened to the ranking member, his problem is those words that he says in subclause 41B, instigate, command. So we can still tidy up 41A. A person shall not engage in conduct, because if you read Article 39 well, Mr. Speaker, with your indulgence, I quote, Article 39 was subject to clause 2 of this article. The state shall take steps to encourage the integration of appropriate customary values into the fabric of national life. So now we want to go into conduct, so that a person shall not engage in a conduct that undermines the proper human sexual rights and Ghanaian family values. That will sit with 39 and still satisfy him with his quest that under Article 39. So that what makes us Ghanaian is what Article 4 will seek to do. Appropriate. That this conduct, in our view as Ghanaians, is inappropriate, will be defined by us. So instead of just leaving the word undermine to stand alone, it should be a person shall not engage in conduct. Then we've now defined that it is conduct that we are targeting. That if you engage in a certain behavioral pattern unknown to our values and norms, you will be capable under the provisions of Section 4 of this bill. Thank you, Mr. Speaker. I don't know if that finds...
Honorable Dafemako.
Speaker, thank you very much. Speaker, these arguments, in consonance with paper and hearts, it's very, very important. Yes. Now, my ranking member and senior at the bar it's a bit worried that I appears to have said things that he didn't say. But the essence of his submission is that we are crafting a provision that, according to him, in Article 39, may not sit well with it. Mr. Speaker, technically speaking, you are saying it's not in consonance. Otherwise, then there's no basis for the objection. That's all I'm saying. So I withdraw those words if they appear to have insinuated things that you didn't suggest. But technically speaking, his second submission, that 4 should be deleted in its entirety, because it's been taken care of in 12, and so 12 should subsist, it defeats his position. Except to say that he's not saying that 4 should be deleted because it's a surplusage, because it's been taken care of by 12. But the subsistence of 12, is so fundamental. The essence of what we are doing in 12 is to ensure that, but like the minority leader said, the Honorable Anna Jesus said, by conduct. What will constitute conduct that will offend this provision? It will be a matter of investigation. So, the suggestion by the committee chairman, the chairman knows that we disagreed. The committee prevailed, and I made the point that I'll take it to the floor. So, the suggestion by the committee chairman that it should be deleted was based on the fact that it offended the Constitution in the opinion contained by the Attorney General. So, Mr. Speaker, I think that the proposal to delete 4 is not warranted. We should proceed and deal with the amendments attaching 4 so we can make progress.
Yes, Chairman, that will be the last contribution. Then I can guide
Right.
the House.
Thank you, Mr. Speaker. Mr. Speaker, it is not for nothing that you once referred to this bill as the most important bill before us. I call it the controversial bill. Mr. Speaker, what we seek to delete, and let me go through the entire clause with your permission. The head note reads, prohibition against undermining proper human sexual rights and Ghanaian family values. Mr. Speaker, at another time, we will seek to amend even the title of the law. So I will not comment on that now. But reading through, as was suggested by my ranking member, a person shall not, A, undermine. What is the meaning of undermine? Mr. Speaker, we are making a law that would withstand the test of time. And we have to go to court to prove if anybody should be found guilty of this law, we have to prove beyond reasonable doubt that the person had undermined the proper human sexual rights and Ghanaian family values. How are we going to achieve this? It is very difficult or almost impossible to prove this. Secondly, it says, Mr. Speaker, B, directly or indirectly instigate, command, counsel, procure it, or in any other manner purposely aid, facilitate, encourage, or promote, whether by a personal act or presence or otherwise, an act that undermines the proper human sexual rights and Ghanaian family values. Again, the committee came to a conclusion that this is very difficult to prove. And Mr. Speaker, we made it clearer that even the pressed men that would be soliciting for views, that would be propagating, even to say that the proper Ghanaian family values bill, they would all be culpable under this law. And there are other provisions, Mr. Speaker, in this bill
Honourable members, please, the position of the committee has been made clear by the chairman and ranking member. Nobody is doubting the reasons that they have adduced for the request to delete the clause. What the other persons are doing is trying to save. If you can't define undermine, could we use other words that could be defined or that are clearer, or words that you can get ingredients of the offense? Now, our attention has been drawn to other provisions that are also meant to do the same thing. Is it possible for us to marry this provision with the other? It's not only one. I think there are 2 or 3 other provisions talking about prohibition. Is it possible? I think so. It's possible. It's a matter of arrangement of the bill. So we could proceed to accept that the submissions of the committee on the lack of not just clarity, but lack of ingredients of that is being created, the offense of prohibition against undermining. And Chairman, we have already amended the bill by the deletion of the word proper. So it's no longer part of the bill. You've been referring to proper human sexual rights. No. We amended that and it's now human sexual rights and Ghanaian family values. So that has been taken care of. Is it possible for us to take what is in 4 now to the latter part of the bill and try to incorporate what is not captured in that latter part to be more comprehensive and to take care of some of the issues that are raised in clause 4. If that is possible, then we could go by the proposal of the committee to delete the clause as it stands now. Having in mind that when we get to clause 12, then we'll take some of the elements that are in clause 4 and marry that to clause 12 and the subsequent clauses. But Chairman, it's not the case constitutionally. That is when the person finds problem with the laws we pass that have concerns that are constitutional in nature. It's not only that. They could be legal, not constitutional. They may be even matters of policy. But the President is not endowed with a veto power. He only makes comments and resubmit it to the House. If the House insists that what we have passed is a writing, the President has no option than to assent to it. Ghanaians are after that permitted to take it to any court or interpretation. So we are not bound to be looking over our shoulder because the President is there to make comments. No, that one should not be our concern at all. We should try as much as possible to do the proper thing. And that is why it's important that we are not pushed to pass laws on the certificate of urgency. The process is tedious. It's a process that you must take time and think through every word. And Parliament should be given that time to do so properly. The reference to the Supreme Court were laws that were passed by the earlier parliaments of the Fourth Republic, not this Parliament. So your reference to this Parliament may convey a wrong impression that is the 8th Parliament. The 8th Parliament hasn't met that yet. Yes, please. Honorable Dafinoko, I thought we had finished. Yes.
Mr. Speaker, I agree with your proposal, save that I want to add that we rather have it stood down. We have it stood down instead of deleted, with the idea that it will be married to 12 further in the bill. I pray that we have it stood down so that we can make progress with 5, 6, 7 onwards and come back to it at another time. Mr. Speaker.
Well, I just made a proposal because I know that there are further amendments to that clause. And so we'll take those further amendments. Then at the end of the day, we'll take the final decision when I'm putting the question. The majority leader proposed amendments to that clause. He's in, and we'll be giving him the opportunity to move them. But before him, then let me listen to the chairman first. Yes, please.
Mr. Speaker, I wanted to draw the sponsors' attention that we want to enrich the bill that they had brought to the House. The ranking member always insists that the bill, as it entered, would not come out the same way it entered. If they don't want me to delete the amendment, Mr. Speaker, I seek to withdraw the amendment I propose. So I accordingly propose that the amendment is withdrawn. Thank you, Mr. Speaker.
I'm not too sure this sits well with your earlier position that this proposed amendment is from the committee and not you. I'm not sure you now have the authority of the committee to change from deletion to withdrawal. So what I'll do is to allow the majority leader to move his amendments. Then at the end of the day, to be clearer to the House as to which path to choose. So please, Chairman.
Mr. Speaker, I think I'm within the remit because I was seeking to withdraw the entire clause. If majority leader is making, giving an opportunity to enrich the clause, then I think it is in order that I shall amendment of deleting the entire clause in order that majority leader can also enrich the clause.
And I said you don't have that authority from the committee. So you wait. Let's listen to the Speaker. Yes, let's listen to the majority leader. Because that proposed amendment is not yours. It's the committee. And so you cannot on your own stand and withdraw it without the authority of the committee. But let's listen to the proposed amendment by the majority leader. Yes.
Speaker, I'm informed that you're dealing with clause 4.
Yes.
And what I noticed was that whereas 3 was dealing with a general purpose, 4 seeks to do some targeting. And so I thought that instead of deleting it as being proposed, we rather let it stand and strengthen what obtains in clause 4, which is why I've come with these amendments. So I would plead with the chairman that they should allow 4 to stand, and then we amend same with what I've suggested.
Let me get your views on the first issue, which is what has pushed the committee led by the chairman to propose a deletion. They are talking about the word undermine. Undermine. What do you mean by undermine undermine the human sexual rights? You're creating a new offense, which is creating doubt, and definitely you have difficulty in prosecuting such an offense. And so they are of the view that if you have to predicate this clause on a word that is not clear, and on a word that if you investigate, it will be difficult to get the ingredients of that offense, and you know that will offend against the provisions of our Constitution. It's in that vein that they are proposing that we should delete the whole clause. And then there are later clauses like clause 12, which are similar in nature. And so my proposal was for us to take note of what they have stated. Yes, truly, the word undermine is too generalistic. It doesn't clarify the type of offense you are creating. It will be difficult to adduce evidence to prove in a court of law. Why not just delete it and then look at the elements that are germane and relevant to the objective of the bill, and then incorporate that in the latter clauses like 12, which are almost on the same, or as you say, pari passu clause 4. And maybe the proposed amendment you have proposed or suggested could be taken on board at that level. Do you agree with the view that it's not easy to define undermine?
Mr. Speaker, I appreciate the explanation that you're giving, and I think that as far as my understanding of this is concerned, I think it has to do with the promotion. The promotion. If you are not promoting it and you are doing anything to downwalk the system, then you are undermining it. I think that is the understanding that I have. You're warping down instead of promoting it. That is what they mean by undermining. And I guess if we have to use it, then we will have to take it to interpretation and define what we mean by undermining. But I'm not at this stage in a position to immediately propose something. So perhaps we further to what may be done to enrich it, we could then thereafter stand it down and then do proper winnowing on that, on 4. But as far as I'm concerned, I think that...
but the clause 12 deals with the issue that you mentioned, promotion. It talks about the same thing, prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act. So there's an offense being created under clause 12 in the same or of the same nature as what is being proposed in clause 4. And that is what the committee is proposing, that clause 4 be deleted. Then we can handle that matter under clause 12.
Mr. Speaker, with respect, 12 and 4 are a bit different. They are a bit different because 12 is predicated on 10 and 9. 12 is predicated on 10 and 9. A prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act. And you realize that it's dealing with the media. 12 is through media, technological platform, technological account, and any other means. So that is different from the general construct in 4. And then you come to 13. 13, that is also continuing from 12. So it's a bit different.
We are not saying they are the same. We are saying it's not possible to incorporate that under. Because I don't seem to agree with you that 12 is predicated on 10 and 11. I don't think so, because 10 deals with gross indecency and 11 deals with void marriage. You see? But yes, you are one of the promoters of the bill, yes.
Mr. Speaker, I think that we should just step this down because I agree with you. 12 and 4 are not the same. 12 and 4 are clearly not the same. What 4 is seeking to do, and I think with 4, what we need to do is just work and clean the head note. Because, Mr. Speaker, what 12 is prohibiting are offenses under the Act. Now, offenses under the Act are specified in 6. And those offenses are sexual right offenses. But if you look at 4 and the reference to 39 of the Constitution, Article 39 of the Constitution, Article 39 of the Constitution is not talking about sexual offenses. It's talking about cultural values, which we have couched as Ghanaian family values. So 4.
That argument that was submitted by the committee, I think is a ranking member. It's not convincing. So we've gone beyond that one. But those are just directive principles of state policy.
Yes.
And they are to guide us. And they are not meant to create offenses. So they are not applicable at all. So that one, we just left that. You are just drawing attention to it. But I think that
Speaker,
we can create offenses from those directive principles and enforce them. It's when we do that, then they will not just be guides, but they will be binding on us. But if you look at Article 35, what is under the directive principle of state policy are guides to all of us, Parliament, Executive, Judiciary, and the rest. And the Supreme Court has ruled that most of them are not justiciable. You see? So we are guided by that. That one, don't go into that area because they didn't get it right. It's the second aspect of their submission that caught my attention. That, look, there are other clauses which are creating offenses. Could we take this and marry it with the other clauses? Not that they are the same, but could we not situate them there than in 4 address that?
So Father, Vice Honorable Speaker, what I'm suggesting is we stand this down and then let 4 focus on Ghanaian family values, offenses in this bill that would focus on Ghanaian family values. Because 12 deals with offenses that are of human sexual rights. 13 deals with offenses that are human sexual rights towards children. We've separated them. So 13 is specific towards children. 12 is specific human sexual rights. And I believe that if we take 4 and make it focus on Ghanaian family values and create the offenses as well there, taking direction from whatever guidelines have been given in Article 39 of the Constitution, that in itself will be a tidy way to do it. So we can stand 4 down and create the offenses there on Ghanaian family values, so that stands alone on its own.
I seem to buy that that view, and I think the chairman earlier on talked about not withdrawing again, but calling for us to stand it down. I think we should stand down this clause, move on, and then it will be reconsidered later on under the title of Ghanaian family values, not human sexual rights. Honorable members, before we go on, we are honored with the visit of students from one of our schools here in Quantanan, Medina. That is students from the Medina Demonstration Basic and Special Unit. So you can see the number is both the basic and the special units that are together. That's quite a large number, and I'm sure they might have used 3 buses or so. They are led by Mrs. Selina Chum Ampofo. Mrs. Selina Chum Ampofo, where are you? Yes, she's behind the, is it the special unit? Yes. They are 123 in number. That's, I think, the largest we've received so far. And on your behalf, I want to welcome them to the Parliament of Ghana. I'm sure they've got their first stint of it, and they see what we do, even though many might not understand, but at least it will imprint in their minds that they were in Parliament when they were in the school. You are most warmly welcome, and we encourage you to keep on coming and learn more than we have done, so that in future you could do better than us. We are grateful that you find time to come. Please, you may now resume your seats. Yeah, so clause 4 is accordingly stood down. We'll move on to clause 5.
Duty to report.
Clause 5, we have only a big proposed amendment. Yes, by the
Thank
time
you, Mr. Speaker.
Yes.
Clause 5. The proposal is to delete clause 5 now, and reasoning for deleting is that we want to make this merge this particular clause with clause 22 when we get there. So the proposal is to delete clause 5 now.
What is in clause 22? Because clause 22 talks about prohibition of extrajudicial treatment.
Yes, Mr. Speaker, this very clause It's talking about a person, I'm talking about 5. A person who is aware that an offense is committed and there's a duty for him to report, and we set a timeline, and the closest that would come, we could come to is the clause 22 is saying whoever commits, this is a misdemeanor, verbally or physically abuses, assaults or harass a person accused of that. So the committee agreed that we would, that, Mr. Speaker, because we've already stood down for, obviously, I may have to agree or discuss the clause 4 with the proponents of this bill and leadership. And if the sponsors are mindful, we could add clause 5 for us to discuss the 2 clauses together and report back to the plenary. I'm grateful, Mr. Speaker. So either if they agree that we should delete clause 5, if not, we could add it to clause 4, and then we could do winnowing at our spare time. Thank you.
Yes, honorable members, motion moved for the consideration of the House. Yes, Honorable Dafiamapo.
Speaker, thank you very much. Mr. Speaker, I disagree with the present amendment being proposed regarding the deletion of 5, so it could be married to 22 later. Mr. Speaker, the duty under 5 is in respect of the commission of an offense. The offense has been created by this enactment. Now, the offense being anticipated in 22 is in respect of extrajudicial treatment. That is, in my opinion, or in my humble opinion, a molestation of a person is termed extrajudicial treatment without subjecting the person to due process of law. You are a duty under 22 to report that. But the duty being imposed under 5 is one regarding the commission of any of the offenses this legislation is anticipating to create. So they are entirely different. So we cannot marry that to 22 and have harmony. In my view, the 22, the imposition of duty under 5 is markedly different from the imposition of duty under 22. These are the reasons why I think that 5 should stay on its own, and 22 should also stay on its own, because their target audience are different. Humbly submitted, Mr. Speaker.
Yes, Honorable Sam George.
Mr. Speaker, it is with great difficulty that I disagree with my co-sponsor, because we had this conversation at the committee and we decided to make this one clause where we've integrated the duty to report in 22, because what we realized as sponsors also was that most of the extrajudicial treatment comes from persons who have knowledge of the commission of an offense, or that is of an activity that is being criminalized under this bill. They have knowledge of it, they fail to report, and then they carry on with extrajudicial treatment. And so what we have chosen to do is to take away that duty to report, because a duty to report cannot be criminalized. The difficulty exists in how do you criminalize the failure to report. But if we put it under 22, the proposed amendment in 22, the first clause there, it reads, a person who has knowledge that an offense is committed under this act shall report the commission of the offense to a police officer or in the absence of a police officer to a relevant authority of the community in which the offense is committed. That takes care of whatever duty to report we are seeking to create in 5, and then that continues to then impose a sanction if you fail to report and then take extrajudicial action. And I think that that is a more tidy way for us to do it than to have the two separated and just have two clauses, one that doesn't necessarily impose any liability. So I'm guided by the position of the committee which we discussed, that we delete 5 and then integrate it into 22, a duty to report and then a prohibition on extrajudicial treatment. Thank you, sir.
Yes, Honourable Member for West Central.
Thank you, Mr. Speaker. Mr. Speaker, looking at 5, I have the impression that it looks like you are in a police state in which a situation you have witnessed, you are compelled to bear witness, but not just to bear witness, to suffer if you don't do so. I think that even if it is to be integrated in 22, it should be less aggressive than we are seeing it. To simply say that if you are a witness, you report. So that, to construct it in manners that would so much burden on a person who is supposed to be seeing something, such an offense committed. If I were the one, and I'm seen to have seen such a thing, and you are imposing all this on me, I will feel very, very offended, and I will feel that the state is against me in an unfair manner. So I think that we should, even if it is to be integrated, it should be mellowed. We should reconstruct it in manners that will not give it this high-pitched tension. Thank you.
Yes, ranking member.
Mr. Speaker, to get the reason for the deletion of clause 5, we have to look at the amendment proposed to clause 22. If you look at the amendment proposed to clause 22, it is very clear that clause 5 has already been taken care of. That is why the committee is proposing that clause 5 be deleted. Mr. Speaker, the new rendition being proposed by the committee in clause 22, 1 reads, a person who has knowledge that an offense is committed and that this act shall report the commission of the offense to a police officer, or in the absence of a police officer, to a relevant authority of the community in which the offense is committed. That is the proposed rendition of the committee. Now, clause 5, as it stands in the bill now, which is being proposed to be deleted, reads, a person in whose presence an offense is committed and that this act shall report the commission of the offense to a police officer, or in the absence of the police officer, to a political leader, opinion leader, or the customary authority. Mr. Speaker, is reporting. So once this has been taken care of by the proposed amendment to clause 22, there is absolutely no need having clause 5 of the bill, which is also a duty to report. Mr. Speaker, I am done.
Yes, Mr.
Speaker, the problem here is the head note. The head note under 22 is in respect of extrajudicial treatment. How is the duty to report affecting extrajudicial treatment? Unless the head note is also being amended But that's not what is being said so far. If we are marrying both and marrying the two head notes to reflect the omnibus amendment to be carrying that provision, then I disengage. But so far as the head note is in respect of extrajudicial treatment, the provision will have to reflect what the intendment in the head note.
Well, I think the House will take note of the comments you've made, and yes, Majority Leader.
Mr. Speaker, I think the duty to report should be separate from what is captured in 22. If you have to marry, then as the Honorable Dafiamako has said, you should then find a way to deal with the correct description of the head note. That's number one. Number two, Mr. Speaker, if you recollect what we did with the Whistleblowers Act, the duty to report is there. The duty to report is there. So if you look at it, you see what is required to be done. If you have to marry 5 and 22, I have no fixation. But I'm just saying that we should then take note. You would realize, Mr. Speaker, that in the duty to report, and I don't like what has been done with the amendment proposed for 22. The officers should be distinct. So there we have a police officer, we have, in the absence of a police officer, a political leader, an opinion leader, a customary authority. You recollect, Mr. Speaker, that we even added religious heads in the Whistleblowers Act. And I want that to be incorporated there. A religious leader, if you look at the Whistleblowers Act. So let's not just mask them up, as has been done in 22. So we provide that distinction and that categorization. So that's all that I think we should do to further improve it. And then again, what has been done, the new constructs. Whereas you are charging the officer in 22, the police officer in 22, to take action within is it 7 days? The duty to report, as captured in 52A, that it should be reported within 7 days, is not taken care of there in 22. So let's look at all those things so that we don't miss anything. So, Mr. Speaker, I guess that is what I would say to you. If we have to relocate, fair and fine, but let's get the categorization of the people to report to rights, looking at what was done with the Whistleblowers Act, and also the period of reporting. Thank you.
Yes, please, ranking member.
Mr. Speaker, I will agree with the majority leader. Now, if you go to clause 22, we delete the 5. When we go to clause 22, we can further amend the committee's amendment to capture the sense in 5 and tidy it up there.
Honorable members, there's good reason why clause 5 should be deleted. So I'll guide you to do so. And then when we get to 22, then we can now capture the essence of clause 5 with a new rendition, but also taking on board the concerns that have been raised by the majority leader, particularly drawing our attention to the timing and also the persons, category of persons to report to, or the authorities you should relate to when you are reporting a commission of an offense under the Act. So I'll put the question. Those in favor of the deletion of clause 5, say aye. Those against, say no. The ayes have it. The motion is carried and clause 5 is accordingly deleted from the bill. We now move to clause 6.
Prohibition of LGBTTAP+ and related activities.
Yes, Chairman.
Mr. Speaker, I have a difficulty here. They advertised as in Roman numbered item number 11, and the proposal is that the committee agreed that clause 6(1)(a) be deleted. But I see further amendments by the leader on that very clause, and that's why I am.
Okay, so let's listen to the leader first.
Yes,
let's listen.
Right.
It means he's not persuaded by your proposed amendment. Yes, Majority Leader.
Speaker, first I did these proposals independent of what the committee had done. And I thought that we could improve the 6(1)(a). I thought it's very verbose. It says the person commits an offense if the person engages in a sexual intercourse between or among persons of the same sex. I thought that we could just tidy up if we just said engages in a sexual intercourse. That person engaged in a sexual intercourse with a person of the same sex. That's the import of 6(1)(a). And the positive there, I couldn't just comprehend. So I thought that we could just state a person commits an offense if the person engages in a sexual intercourse with a person of the same sex. That's it. Simplicity. And then you come to...
Before you move on, I don't know whether they considered the issue of gala. You know, it's not, I say gala. It's not just a sex between two people, but multiple, where you have an orgy section of a number of three, 4, 5 people at a session. And maybe they had that in mind in this proposal. Yours is about 2. You are talking about 2 people. But no, you say with a person. The singular includes well, interpretation, yes, singular includes plural, I know. Is that different? Yes, Sam George.
Right, Honorable Speaker, I was worried that it was with a person as singular, but if we are being guided that singular would have a purposive interpretation of multiple, because there are instances where you can have 3 persons of the same sex having sex at the same time. And so if you say with a person, that's why we did it between, so that there will be more than one person. But if with a person would, like you said, in the case of an orgy still apply, then we will go along with it. I just wanted to update the knowledge of the majority leader, because what he knew in 1957 is not what is happening in 2023.
Mr. Speaker, the committee's view was that, and this is the gravamen of this, I have to remind my friend that we refer to Section 104 of the Criminal Code, the Criminal Offences Act, and we said that sex between same sex had already been catered for by Section 104, and it is part of the existing law. And we wanted to expand other clauses of this very section, subclause 3, I suppose, to create a broader prohibition to include sexual intercourse between females. I don't know how they do it, but we made an attempt to do it. But sexual intercourse between males is catered for under section 104. So the committee agreed that it is part of the existing law. Mr. Speaker, I need your protection. My leader is confusing me.
Don't allow your leader to confuse you. You go on.
So, Mr. Speaker, I think that is the agreement we made, that we will delete subclause 6, subclause 1A, and then we would expand other areas to cater for sexual intercourse between females and ignore sexual intercourse between males, as that is part of the existing law. I'm grateful.
Well, let's listen to the promoters.
Okay, Right Honorable Speaker, I think that we are aligned with the position of the chairman, because if you look at the provision in 6.1, it is espoused better in 6.1a. It is clarified and expounded in 6.3. And so what we have done in 6.3, there's a proposal in 6.3 that takes the language of section 104 into consideration and uses that to define and spell out what it is. So that's why we aligned ourselves with the deletion as proposed of 6.1a and then capture it in 6.3.
Yes, Majority Leader.
Mr. Speaker, I heard first of all, we should understand that what is being done under this law, part of it is a consolidation. It's a consolidation of the existing. You should not forget about that. Part of it is a consolidation of even laws existing before this one. So I don't see the justification. I don't see the justification. Second, Mr. Speaker, the chairman was talking about the fact that he knows of male to male. He doesn't know of female to female. But Mr. Speaker, I think it's tidied up. It's tidied up when you say that a person commits an offense if the person engages in sexual intercourse with a person of the same sex, whether it's male to male or female to female. It tidies up. So I don't understand what he's saying. So I would urge the chairman to understand it in that context. A person commits an offense if the person engages in sexual intercourse with a person of the same sex. So, Mr. Speaker, I don't see why he is calling for deletion.
Mr. Speaker, I think I'm convinced by the goalpost interpretation from the majority leader, because it appears to me that 6.1a is the offenses and 6.3 is the interpretation of the offenses. So they are not one and the same, and one cannot replace the other. So if that is the understanding I get from the majority leader, then 6.1a must remain, and we carry along with his amendments to 6.1a, because that is stipulating the offenses, but 6.3 is interpreting or defining what sexual intercourse is in light of section 104. So they are not one and the same. So this one I yield to the majority leader and his ancient knowledge. Thank you.
Yes, ranking member.
Mr. Speaker, I am also convinced on this note. I will urge upon the chairman of the committee to abandon the amendment.
Well, Chairman, what do you say to the appeal?
Mr. Speaker, my ranking member, who is a leader of the committee, our instructions was that we delete 61A. For instance, the A is in 3 parts, and I don't know if its mind has been abated to the other one. Sexual intercourse between a man and an animal, or a woman and an animal. This is already part of the existing law. So we should be careful not to repeat the existing law here. So I thought it would be better if we delete it. But if that is the sense of the House, Mr. Speaker, I'm only So I would, Mr. Speaker, I will urge my colleagues to look at A in the 3 parts, and if they are mindful that we leave it there. It's AI, AII, and AIII. Very well.
Honorable members, our attention has been drawn to the fact that 61A is part of the existing law. I 61A Roman 1 and Roman 2. Now, I'm not sure whether the proposed 61A Roman 1 captures exactly what is the existing law. Because the new rendition that the majority leader has proposed seems to sit well with members, and it's a preferred rendition to whatever might be in the existing law now. Honorable Dafimakwo.
Speaker, yes, I am also in support of the provision in 61A III subsisting on grounds that it rather enhances the penal provision in 104 of Act 29. This is an enhancement. Mr. Speaker, you must have heard that there has been investigations of complaints of the offences insinuated in Section 104 of Act 29. But the police have not been able to effect prosecution because of inadequacy of evidence. But this provision, the way it's been itemized and couched, it's such that it brings clarity to the issues, so that when the police are investigating, they know exactly on which legs to stand to look for or to look into the matter. So far as it is not inconsistent with the existing provision in 29, I believe that it should subsist to give better rendition and effect to the law. Mr. Speaker, I also want to draw the House attention to 61B. That let's deal with this first. Okay, thank you very much. So, Mr. Speaker,
what I'll do is to put the question on
yes.
proposed amendment by the majority leader. Honorable members, those in favor of the proposed amendment by the majority leader say aye. Those against say no. Honorable members, the ayes have it. And so 6(1)(a) Roman 1 will now read, engages in a sexual intercourse with a person of the same sex. We still have the proposed amendment by the chairman. Well, that deals with more than 6(1)(a) Roman 1. It deals with also Roman 2 and Roman 3. Our chairman, the proposed amendment by the majority has been carried. So what do we do with the second or third leg of your proposed amendment?
Mr. Speaker, the initial proposal was to do away with the entire 6(1)(a).
Yes.
But now that 6(1)(ai) have been saved, I will still move that we do away with 2 and 3. We have dealt with pansexual. That is Roman number 2, II and III. So that we would have 6(1). Then it will read, a person commits an offense if the person engages in a sexual intercourse with a person of the same sex. That should be 6(1), and then we'll do away with the rest. Thank you, Mr. Speaker.
You haven't got it right. Yes, majority leader.
Mr. Speaker, for 6(1)(a) Roman number 2, I propose an amendment. Unfortunately, it's not been captured here. And the amendment is this: a person commits an offense if the person engages in a sexual intercourse with an animal. As simple as that. With an animal. And that could be a male or a female. Because 6(a) Roman number 2 says engages in the sexual intercourse between a man and an animal, or a woman and an animal. Both are persons. A man is a person, a woman is a person. So just say engages in a sexual intercourse with an animal and end there.
That looks cleaner and better. Yes.
Mr. Speaker, I support the amendment because of the opening phrase. The opening phrase is, a person commits an offense if the person engages in. Then when you read it with the proposed amendment, it is neater.
Honorable members, this is consideration stage, so I can admit it to...
Mr. Speaker,
yes.
I would want to draw my ranking member's attention that whether we would want to pass this for emphasis or we would want to, because I still maintain that I don't have the Criminal Offences Act here, but all these are catered for in the Criminal Offences Act. So if we have to repeat it...
My attention was drawn to that, but I'm told that they are not couched in the same ways, and that there is some difficulty in prosecution because of lack of clarity. So since this one is in the nature of like consolidation, there are a lot of offenses from various existing laws that are being put together. Once they are dealing with human sexual rights and Ghanaian family values, this law definitely, you know, your law of interpretation, will take precedence over the other ones. So there's no harm in doing it well. Yes, Honorable Dafimapo.
Speaker, indeed, in Act 29, there's a provision that penalizes the offense of corruption. But this House, in the OSP Act, we incorporated offenses on corruption. So once it enhances the existing law, this House, by practice, has enacted provisions that goes to enhance the existing law. So, Mr. Speaker, I think that the provision, as variously amended, should be part of the six, Mr. Speaker, humbly submitted.
For the law you passed on the establishment of the Office of the Special Prosecutor, I did tell you that it was an act in futility. You were not going to achieve anything from that, but you went ahead to pass it. I disagreed with you, but I was alone. Well, I'm very clear in my mind that that authority is embedded in the powers of the Attorney General, constitutionally. Who delegated to who? No, but that is not what you put in the Act. What you just need to do is to fund the office of the Attorney General well and remove the Minister of Justice. You separate the two. Minister of Justice is a political appointee. The Attorney General is a technical person, and he only is ranked in conditions of service to that of a Minister of State. It doesn't mean they have to be incorporated too. Oh, I'm talking about the Constitution. No. I have it. I have my Constitution with me here. We are not Supreme Court, so we don't have that power. Yes, it's there, 881. I have no problem. I have no problem with Attorney General being a minister. I'm only saying you separate that from the Minister of Justice. Yes. Honorable members, so to have put the question on the rest of, not the rest, but 61A Roman 2, those in favor of the new rendition, and that is, a person commits an offense if the person A engages in a sexual intercourse with an animal. Those in favor say aye. Those against say no. The ayes have it.
Or other, whether male or female, I think pansexual is taken care of. And therefore, I think that at this time we should do away with pansexual, especially when in ye, we have also said that if a person holds himself or herself as pansexual, the person commits an offense. I think we can delete the 61A III. Thank you, Mr. Speaker.
Yes, Honorable Dafimapo.
Mr. Speaker, I'm surprised my chairman because pansexual has been defined. It's the more reason why it should stay. Mr. Speaker, if you go to the definition, the provision on definitions, pansexual means a person who engages in a sexual or romantic activity with persons of any gender identity or enhances the various facets of the offenses that we seek to prescribe, including sexual activities, including pansexual activities, Mr. Speaker. I thank you.
Well, Chairman is just maintaining his earlier stand. His stand was for us to delete the whole of A. So once you manage to save Roman 1 and Roman 2, he's trying to also for his Roman 3. I think he hasn't deviated from his stand. Yes, Chairman.
Mr. Speaker, I would want to draw the responses of except I don't understand pansexual, but I thought that pansexual would be attraction to, it will read that a person commits an offense if the person engages in a pansexual activity. And we have that already, because if the person holds himself or herself out as VI, a pansexual, that is created, and that will be a duplication, and that's why I'm seeking to delete pansexual activity. Then it is better couched in ye if he holds himself out. That is, if any other sex is attracted to that person, that will make more sense than to say put it under 6(1)(a). Thank you, Mr. Speaker. So I still think, I know that my majority leader doesn't agree with me, but I still think that we should delete that.
Well, we've heard you, Majority Leader.
Speaker, the pansexual activity is defined, and is defined to include not only sexual intercourse, but romantic activity, which is not covered. Which is not covered in the earlier one. Which is why I would want to plead with the chair to drop the deletion, because romantic activity is not earlier on covered anywhere. So I'll plead with him to drop it so we'll make progress.
Deletion. Because clearly the proposed amendment by the chairman deals with deletion. Those in favor of the deletion of clause 6(1)(a) Roman 3, that is, a person commits an offense if the person engages in a pansexual activity. We have been called upon to delete it. Those in favor say aye. Those against say no. No. The noes have it. The noes have it. The motion is negatived. Honorable members, we now move on to the next proposed amendment by Honorable Seche Mensah-Bonsu on clause 6.
Mr. Speaker,
that is X111. Roman X111. Yes, sorry.
Before we move to the advertised amendment in the name of the majority leader, I wish to propose a small amendment to the provision in 6(1)(b) to the effect that that's where we are. That's where we are. To the effect that a person commits an offense if the person marries or purports to marry a person of the same sex, Mr. Speaker, so that who is deleted as well as that person is also deleted. So the new rendition is A person commits an offense if the person marries, or when a person marries a person of the same sex. That's all.
Simplicity.
If a person marries a person of the same sex, a table of his. Okay, let me take it again. A person commits.
I have what you stated. It's only the when that was going to create problem, but now you went back to the if, so it's all right. Honourable members, the proposed amendment is to the effect that 61B, a person commits an offence if the person B marries or purports to marry a person of the same sex.
Mr. Speaker, humbly,
not purport to marry.
Further taking away purport.
So that they say marries a person of the same sex.
Of the same sex.
Because I know that in criminal law, purporting can
An offense.
Yes.
Yes.
So I don't know why you want to delete it. Yeah, purport too.
Okay.
Yes.
Well, Mr. Speaker, I'm guided, so the purport should stay. I'm guided. Thank you.
So marries or purports to marry a person of the same sex. Those in favor say aye. Those in favor say aye. Yes, please. Chairman.
Mr. Speaker, I thought he withdrew the amendment when you guided him. So
No,
I didn't know what we were voting on.
He did not. He did not. I'm putting the question on 61B, which reads, a person commits an offense if the person B marries or purports to marry a person of the same sex. Those in favor say aye. Those against say no. Yes. Majority leader, what is it?
Mr. Speaker, for the avoidance of doubt, let's not leave out the last three words. As that person, just for the avoidance of doubt. I agree with you that the who is should be deleted. But as that person, yes, it should remain. Just for the avoidance of doubt.
Speaker, I support the further amendment to this provision. Thank you.
We need an explanation.
So that the new rendition, Mr. Speaker, will be a person commits an offense if the person marries or purports to marry a person of the same sex as that person.
What does that mean?
Mr. Speaker, for instance, a person who is biologically male and undergoes some hormonal transformation and medical processes to become artificially female and decides to enter into some marriage or civic union with a person who is biologically male, as that person is what to satisfy, is what to create the offense.
I'm sure you don't understand it. The way you explain it. Yes, Majority Leader.
Mr. Speaker, the elucidation on it is the object that we are dealing with. A person commits an offense if the person, that is that person introduced, the earlier one, commits an offense if that person, if the person marries or purports to marry a person of the same sex as that person, that's the original person. So it's the a person who now becomes the person who now becomes that person. Is just to, provide further clarity. Even though what he said initially makes sense, but I'm just saying that for the avoidance of doubt, so we know who we are talking about. The object, the first person, a person. The same person now is the person, and that person is that original person who marries a person of the same sex. So just for clarity. And I hope the eternal litigant will not pick up any issue with us. I'm standing. You can't stand. Let's move on.
Yes, ranking member.
Mr. Speaker, I will resist the temptation. But, Mr. Speaker, if we are talking about the same sex, we are talking about same sex of that person. So, without adding of that person, it flows. It flows. For instance, I am a male. So if I'm getting married to a person of same sex, it is a person of same sex with me. So without bringing same sex of that person, it is clear. There is no ambiguity. So the introduction of that person into the rendition is not adding any value.
That is why I said it's just for the avoidance of doubt. It's just for the avoidance of doubt, because the object, it doesn't take away anything. It doesn't take away anything. It's just for the avoidance of doubt.
So, honorable members, I put a proposed amendment by the majority leader. Says 1B, a person commits an offense if the person marries or purports to marry a person of the same sex as that person. Those in favor say aye. Those against say no. The ayes have it. The amendment is carried. We move on to Roman 13, right? At page 31. That's a proposed amendment by the majority leader.
Mr. Speaker, I was just saying that for 6C, line 4, you have the word biological anomaly. Now, if you come to 6F, it becomes biological abnormality. And also 6G, Roman 2, biological abnormality. So just saying that we should be consistent. If you're using anomaly, let's use anomaly. If it's biological abnormality, let us be consistent. So that's what I'm drawing attention to. So either of them, let's be consistent with. If we are clinging to biological anomaly, then should go through the others. if it is abnormality, we should be consistent. So I guess I will leave it to the chair. Let's be consistent. That's the proposal that I'm submitting.
Yes, honorable members, I think the word is abnormality. Abnormality. So I put the question on the motion. The motion moved by the majority leaders for us to delete in 6 subclause 1 paragraph C anomaly and insert abnormality. Those in favor say aye. Aye. Those against say no. The ayes have it. The proposed amendment is carried. Now we move to Roman 14. There's a proposed amendment from the chairman of the committee. Yes, Chairman.
Mr. Speaker, amendment proposed, sub-clause 1 of 6, paragraph D, after animal, add or object. So the new rendition would be, a person commits an offense if a person marries or purpose to marry an animal or object. I so move, Mr. Speaker. It is so because in these days, as my colleague Honorable Sam George said, that what pertained in the 1957 is different now. These days, people are getting married to rivers and apart and other objects. So it is important that we add object before it is caught up with us. I so move, Mr. Speaker.
Object. How do you marry an object? They do. What is marriage redefined or what? Yes.
Right, Honorable Speaker, to support the amendment, there is actually evidence, and I can tell, of a man who's married his 1978 beetle, and he is the subject of a BBC interview where he engages in intercourse with his 1978 Volkswagen beetle and reaches an orgasm. And it is a legal marriage. So when he talks about marrying objects, there are people who've married statues and trees.
Animals, crocodiles.
So, Mr. Speaker, it is a real and present danger we are talking about. There are people who are married that have been carried, it's been carried in a BBC interview which we can make available to the table office. So objects have become things that people are getting married to. And so if we are restricting marriage of persons to same sex or animals, it's important that we add objects as well, to make it inanimate objects, to make it holistic. Thank you.
Well,
Mr. Speaker, with your permission, let me even add that right now we have sex toys, sex dolls. Dolls. These dolls are objects. Yes. They are inanimate objects. But people buy these dolls, they marry the dolls, and have sex with it. There are even robots. Yes. That people are marrying.
No, I'm not up for having those kind of abnormal acts. My worry is about the word marriage. How do you to marry? You know, not to indulge in some perverse act, but marry.
Speaker, indeed, I'm very happy you are posing these questions. It's about the legal regimes in those jurisdictions that recognizes, that's why they don't call it marriage technically, so they call it civil unions. And they recognize that the person who is proposing to have that union with this inanimate thing is his right under law. So it must be recognized. So to enter it in the marriage or in the marriage register that the person has a union with this object or with this animal under their law. So it may sound very strange to us, but it is so normal. So this is why we have to forbid it.
This word normal.
Yes.
Are you sure it's normal?
Mr. Speaker, what is abnormal to this house, to this nation, is so normal to some other group of people in some other nations.
No, we are passing a law for this nation, not for any other society. That's why you are talking about Ghanaian family values.
Exactly so, Mr. Speaker. That is why we cannot purport to bring what is normal elsewhere to normalize it here. So what is not normal is not normal, Mr. Speaker, within the four confines.
So you agree with me that it's difficult to marry an object in this environment?
Mr. Speaker, but somebody may want to do so tomorrow. The law should be able to
You yourself stated that it's done in environments where they recognize civil unions.
That is so.
Not the type of marriages that
we recognize. Yes. Yes.
Honorable Speaker, respectfully, if you go
Chairman, I will come to you. Yes.
If we go to 11 in the bill, we have void marriages. And what we do is to prescribe marriages that are contracted outside the jurisdiction of this country and states that they would have no validity in Ghana. So it is extremely important because, and just here, I just showed them, an Indonesian man married his rice cooker and divorced it 4 days later for being able to cook only rice. But he had a marriage certificate and took it to court to divorce the rice cooker. And that's the story I'm reading here. So, Mr. Speaker, if such a person has a marriage certificate with his rice cooker in Indonesia and comes to Ghana and seeks to say that he had contracted this marriage outside the shores of Ghana and seeks certain benefits of married people in Ghana, that is why we are voiding such marriages in 11. And that is why it will be important that once we are voiding all marriages that are not normal to the Ghanaian context, but contracted outside, when they come into Ghana, it is also important that we state that marriages with objects outside the jurisdiction of this country would not be recognized when you bring whatever certificate it is into Ghana. Because 11 talks about voiding marriages contracted outside Ghana that are abnormal.
Yes, Chairman.
Mr. Speaker, as I said, I lead the committee and I express the sentiments of the committee. Clearly, this has been defined at the committee level. And this bill, as we have it, most of the clauses are in anticipation of what will happen tomorrow. It is not that the laws of Ghana, as we have it now, the laws of Ghana, there is a law on unnatural carnal knowledge. The DAOs that we talk about, it is an unnatural carnal knowledge, and the laws take care of that. Apart from that, Mr. Speaker, the other things, the marriage between a man and a woman, we have not annulled the law to say that a marriage between two people or of the same sex is allowed in Ghana. It is currently, the current law doesn't allow any of these things. So I see this, and we have discussed it at the committee level. There is no law in Ghana that will give rise to any individual, whether man or woman, to get married to an object in Ghana. It is illegal in Ghana as we speak now. Mr. Speaker, I leave it with the discretion of the House. But that is the proposal and the sentiments of the committee that we should add object.
Well, honorable members, we are being urged to add or object. So I'll put the question. And that is coming from the committee. That 6(1)(d) should read, a person commits an offense if the person D marries or purports to marry an animal or object. Those in favor?
Speaker, before you put the question, I want us to go back to 1B, because this is marriage. This is marriage. What of having a sexual intercourse? Are you going to then amend what you have just done in 6(1) Roman 6(1)(a) Roman number 2? A person commits an offense if the person engages in a sexual intercourse with an animal. Are you then going to add or object? Are you going to add that? If you do add that, Mr. Speaker, that may be a difficult thing. It may be a very difficult thing. And I believe people understand.
Well, that's a different sub-clause. Yes, let me just listen to you.
Mr. Speaker.
That Honorable Vondi.
Yes, Mr. Speaker.
Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, marriage between two people is consented. Two people must agree. Mr. Speaker, I'm just failing to understand how an object is going to respond to a proposal and to get married to. So, if you call that kind of thing a marriage, Mr. Speaker, I really fail to understand how that can become a marriage. So if you say a person married to an animal and an object, the object cannot respond to a proposal for marriage. Neither can the animal. Mr. Speaker, that's my contention.
Actually, I was of the same view. Then yes. I realized that even the animals, they can also consent.
The animal may, if you like, express, but even then, for objects, Mr. Speaker, I really don't see how an object can respond to a marriage proposal. So if you can limit sexual intercourse, having sexual intercourse, Mr. Speaker, I think that will help us. But to say a marriage, Mr. Speaker, I don't really see how it happens to marry. Thank you, Mr. Speaker.
Well, this well is not our own, so we are just passing through. Maybe they are, as they said, they are not looking at only today. They are also looking at tomorrow, because it's an enduring legislation, so they want to capture enough to cover what may happen tomorrow. The degeneration going on in our society these days is unimaginable. Yes, Honorable Mama Yarga.
Thank you very much, Mr. Speaker. I think it is important to understand the context in which these proposals are being made. It is perfectly possible that a group, a sect, some organization can, purport to be performing the functions of assisting parties, human or otherwise, to establish relationships that they would choose to characterize as marriage. And I think the object of the proponents of this bill is to have us outlaw such conduct. And so I think that it is possible. We've seen it in other parts of the world, and I think that is what we are guarding against. And we're not talking about actual marriage. We're also talking about purporting to be married. And so I don't think that this proposal is out of place. And I also know that so many things are happening. Mr. Speaker, there is a whole wave of artificial intelligence, and human beings are being designed, mechanically cloned, and some actually look like human beings and have been wired to perform certain functions, Mr. Speaker. I didn't say sexual functions, but I'm saying that they have been wired to perform certain functions. Mr. Speaker, I will not be surprised. I will not be surprised to see people, try to establish what they, in their minds, perceive to be marriage with inanimate objects, as we see. I mean, we go to airports, we travel, we see, artificial intelligence informing some human beings purportedly carrying out functions that ordinarily, have always been performed by human beings. So we must think extensively when we are designing legislation to guard our, social values and our morals and family values. So I think, Mr. Speaker, that the rendition, there's nothing wrong with it, and it makes it complete to add the word object to that clause.
Yes, Regional Minister.
Mr. Speaker, thank you very much for the opportunity. Mr. Speaker, may I respectfully find out from my colleagues and seek your guidance. In which context do you define object in this matter? Mr. Speaker, I say so because in this part of the world, there are processes that lead to marriage. It goes through, unlike the Western world where one-on-one you can go to register general and register. There are culture in this country or down in this part of the world. We go through some processes. Indeed, if we are not careful and we don't define the word object, and this, we are likely to get ourselves into trouble, because it means that if I have something at home and I choose to marry that person, then I'm okay to marry the person. Is that what we want to say? The Speaker, to add to it, I've taken a careful glance in the chamber, and it appears that there is no gender balance in this particular discussion. I do not intend to truncate the process, but unless...
Your house itself is not gender balanced.
No, but the Speaker, unless
we have a number of
Deputy Chief Whip is going to stand in for the women.
We have a number of men, we have a number of ladies in the house. So
the Speaker, they are only three, but unless Deputy Whip wants to stand in for the women, so tomorrow they don't say that they were not part in the consideration. Thank you very much, Mr. Speaker.
Yes. What really they're trying to do is to outlaw it. And a Ghanaian could contract such a marriage outside and then come to Ghana and try to benefit from provisions of marriage persons because he has been married to an object outside. And so this provision is meant to prevent that we will not allow it, we will not recognize such a marriage. So you are covered. Chairman, I think you succeeded, so I wanted to put the question.
Before that, Mr. Speaker, like I said, being a member of the House, I wanted to draw the House's attention to what pertains in Ghana. Now, my colleague asked the question, we are talking about marriage in Ghana. Somebody purports to marry in Ghana, or he marries an object. And I am drawing the attention of the House that this is illegal in Ghana as we speak now. No marriage, all the laws, the marriage laws in the country does not anticipate objects. So, are we making law in anticipation of what it would happen tomorrow? The laws of Ghana, when we are talking about marriage now, is a marriage between a man and a woman to the exclusion of all others. There are 3 marriages in Ghana. the Mohammedan marriage, the Islamic marriage, people call it Islamic or Mohammed, and the Christian marriage, and the traditional marriage. The traditional marriage, none of them anticipates any marriage of this sort. And that is the law of the land. And now, because somebody had gone to do it outside, how is the person going to enforce it here? We are not saying if the person comes in with a marriage to enforce it. It is a person who marries in Ghana that we're making a law to ban. And if the person is marrying an object, that is what we are saying is not allowed. But the laws of our land doesn't allow it in the first place. That's my worry. Even though I carry out the sentiments of the committee, personally, I agree with the other member that raised you cannot engage in a marriage with an object. And I say so because the Ghanaian law, the Ghana law, doesn't allow anybody to anticipate that. And therefore, I would be grateful if we could do away with objects.
You, Chairman, you are talking about Ghana law because that has been legislated by the authorized body of Ghana. Either it's in the Constitution or it's a law passed by Parliament or decrees. And so the same authority is now passing a law. And so that earlier law will now change. There's nothing wrong with that. But we are saying that if you contract such a marriage outside, and then you are in Ghana, and there's a provision, for example, giving some benefits to marriage, contracted such a marriage with an object, then you try to benefit from that provision. That marriage you contracted, recognized by our law in Ghana, is meant to achieve. And I don't think there's anything wrong with it. I'll just put the question. Those in favor of the proposed amendment, which reads, a person commits an offense if the person marries or purports to marry an animal or object. Those in favor say aye. Those against say no. Honorable members, the ayes have it. The amendment is carried. We will need to finish all the amendments on clause 6, and then we can take a suspension. So please, be mindful of that. We move on to the next proposed amendment, which is Roman XV, and that is 15. It stands in the name of the chairman of the committee.
Thank you, Mr. Speaker. Amendment proposed, subclause 1, paragraph E, subparagraph V, delete. Mr. Speaker, the word is, V is a queer, and the term queer at a committee meeting had been used for any person that is within the LGBTQ community. And therefore, we thought it wise to delete 6(1)(e)(ving, a queer, because it refers to, well, if you are lesbian, you are queer; if you are gay, you are queer; if you are transgender, you belong to the queer class. So any person that belongs to the LGBTQ, and that's why I seek to delete V. I so move, Mr. Speaker.
Yes, actually, earlier on at clause 1D at page 4, this thing was done, and I think the consequential amendment was directed. The explanation gave to the House then exactly what the chairman said, where covers, the term where covers all those areas they spoke about. And so they asked us to they asked us to delete from the clause 1D at page 4 and reduce it to LGBTTAP plus, which was so decided by the House. When we started, that is how the House was convinced to delete it. And so he's just following on that, unless you want us to revisit that issue. Yes, Majority Leader.
Mr. Speaker, I'm struggling to appreciate what the chairman said, being amplified by your good self. It says a person commits an offense if the person goes out as a lesbian. That is a gay, a transgender, a transsexual, a queer, a pansexual, an ally, a non-binary. Mr. Speaker, I'm struggling to understand why you are deleting only queer. Because, and you are saying that is provided for in the usage of the term LGBTQ. But L is there, and L is lesbian. Why aren't you deleting that? The G is gay. So if I could have better explanation, because I'm not appreciating raised by the chairman of the committee.
Actually, you didn't get all what he said. Yes, ranking member.
Mr. Speaker, this amendment is consequential as indicated by the Speaker. Mr. Speaker, the reason is that the word queer is an umbrella term for any person who is not heterosexual. If you are not cisgender, we refer to it as queer. So a lesbian is a queer, a gay is a queer, transgender, so it relates to all of them. So once you have listed them here, there is no need using the umbrella term that refers to all of them. That is why we are deleting.
The majority leader is so happy that you are not using elephant, you are using umbrella.
Very well. Mr. Speaker, in the circumstances and where we are, umbrella is the one that fits the situation. Elephant will not fit this situation. Mr. Speaker, if you have seen elephant in this chamber, we won't be running away.
Well, elephant, depending on what type of elephant, but I know it's a very calm, nice animal that you can play with, you can ride, you can even take as a pet. I know that. And I know that some of you were even holding umbrellas and sitting on elephants. And nothing happened to you. Yes. Let me listen to Majority Leader. I'll come back to you.
Mr. Speaker, what explanation that has been offered rather should lead us then, if we are to believe what he said, then we don't even need any other thing that you've written there. Just use queer. It's the opposite of what they are saying. If what you are telling us is that queer is your umbrella or canopy term or whatever you decide to call it, or elephant term, Mr. Speaker, then it means that you rather need to employ the word queer and leave the rest. if what you are saying to us is right, it's rather the converse. So what you are saying is rather wrong.
They actually have changed the explanation. Well, at clause 1, that was not the explanation you gave. Yes, yes, Mama Yaria.
So, Speaker, I was actually going to argue along the lines of the majority leader, but to also add that, let's leave it there so that if there is some other category that we haven't captured in our legislation and itemized, then the queer will capture that category. Yes. So let's leave it. Let it remain. So that if we have missed out anything, and somebody comes and says he is not gay, he is not he's not transgender, he is not lesbian, but that there is a new category that we don't know. So it's better to leave it there for the avoidance of doubt.
Why do we also end up with plus? Then why do you have plus there? Because the plus is to take care of situations like what you talked about. Things that have not been identified, that have not been itemized, they erupt later on, that's a plus. Let me listen to Chairman. Chairman has stood up a number of times.
Yes, Speaker, I want to take the sail out of his wings.
You want to take the sail? Okay.
Yeah.
Chairman,
Chairman,
you want to permit him to do so?
Commutatively, Mr. Speaker. Mr. Speaker, in that case, a rather should read a person holds out as a queer, including the release these things. That would be better. But to take it out, really, you are agreeing at the set.
Chairman.
Mr. Speaker, I think the rendition that the majority leader gives better captures what we're discussing.
So he was right that he wanted to take the wind out of your sail.
Earlier on, when it said that my colleague, the ranking member, said that the queer was an umbrella word. And Mr. Speaker, he never said a colored umbrella. He said it was an umbrella word. And that was taken.
Actually, I've not come across an umbrella that is not colored.
Mr. Speaker, we have black, white,
so black
green,
is a black is a
but not multicolored.
You didn't say multicolored.
Umbrella.
Black is a color.
So I meant multicolored, Mr. Speaker.
Now I hear you.
I think that this is a better rendition because, Mr. Speaker, I'm not an expert, very expert in this area. I don't want to mention names. Some of my colleagues are. But they expressed and taught us that the term queer is used for any person that involves himself in this LGBTQ plus community. So the rendition that the majority leader gives is better captured. So we can go along with that amendment. Thank you.
Honorable members, if you keep on changing these terms this way, the whole bill will have problem with it. Well, you'll be using the LGBTTA plus, AP plus. Now, if you do this rendition, that means we can go and use queer inclusive and then you itemize throughout the clauses. If you want us to make a consequential narrative, we can do that. If not, then we have to leave it there. You have to put Q in the earlier clause 1-2.
Mr. Speaker, consequentially, we can do that.
I want to listen to the chairman.
Yeah, Mr. Speaker, let me apologize. 2 days ago, when this bill was started, the committee was meeting on a number of estimates. So I didn't get the benefit of the definition for queer. But I may want to add here that if we have to adopt what the majority leader is saying, we may have to add, but not inclusive, but not limited to, then we can add them. But I don't know what was captured.
Why that verbosity? Because when you say inclusive, it means it doesn't limit the number. You can keep on adding. It means it's more than what you stated. I don't understand. Yes, honorable members, I'm tempted to allowing it to stay, but that depends on the decision of the House. Yes, please.
Mr. Speaker, so we wanted to say that we should go with the suggestion of the majority leader so that it will read, a person commits an offense if the person holds out as a queer, including, and then lists I, a lesbian, I, a gay, and then continue that way without the queer in that listing. And that would also have some consequential effect on clause 1, as we amended earlier. If it pleases the Speaker.
It's not about pleasing the Speaker. It's about having to redraft the whole bill. Because of the bill is drafted with all those LGBTQ and all those clauses, and the structure of the renditions will have to change with this new amendment. That's why I say there have to be a new redrafting of the whole bill. Yes, please.
Mr. Speaker, I made that proposal because of what the chairman said.
Yes.
So it's one of two ways. Either we do it that way and go back, or we can let the queer be there. Be there.
Yeah, that's what I said. I'm tempted to agree.
And don't delete, as the chairman is saying, with the understanding that we have. So that then we go back to 1. If we deleted it in 1, then we should go back and reinstate it. Otherwise, once we touch it here, it's going to affect the entire constructs of and that's going to take some doing. So we can go back to 1, reinstate it, and then also leave it here.
So, honorable members, we are being prevailed upon to allow a queer to stand in clauses 1E, and therefore I could make consequential order that in clause 1, the queue be restored. Are we together? Chairman.
Mr. Speaker, in that case, I have to withdraw the amendment.
Okay, honorable members.
So accordingly withdraw the amendment.
Okay. Honorable members, the proposed amendment numbered XV is accordingly withdrawn. I will proceed to direct that consequentially clause 1 earlier on amended at the deletion of queer, the queer be restored. And so it will run throughout the other provisions of the bill. So you now have it as LGBTQAP+. Honorable members, we move to the next proposed amendment. It stands in the name of the chairman of the committee. Yes, Chairman. XVI.
Subclause 1, paragraph C.
Paragraph E.
Paragraph E. Subparagraph V. I. Delete pansexual and insert bisexual. Mr. Speaker, we agreed to this as a committee because we looked at the definition of pansexual, and bisexual is a better rendition and suits the purpose better than pansexual. I so move.
The definition of pansexual and the earlier decisions we took. Yes, Honorable St. George.
Right, Honorable Speaker, unfortunately we cannot support this amendment because even when you read the definitions, the interpretations given, the definition for bisexual and the definition for pansexual are different. And a bisexual is defined as a person who is attracted to persons who are of the same sex as that person, or to persons who are of the opposite sex. So in layman's language, a bisexual will be someone who is a man and has sex with both a man and a woman. But a pansexual is a person who engages in a sexual or romantic activity with persons of any gender identity or expression, including persons who do not fit into the binary sex categorizations of male and female. And why pansexuals are different is because they are individuals who do not consider themselves male or female, but yet engage in sexual activity and don't find themselves or identify as either male or female. So such persons would need to be covered by the use of the term pansexual. So that is completely different from bisexual. So we should have pansexual still stand in the bill.
Majority Leader.
Mr. Speaker, I want to believe that the motivation for the chairman calling for the deletion of pansexual and the insertion of bisexual is because in 1A, the committee proposed the deletion of the entire 1A, which includes the pansexual. But after we have agreed that you stay, the chairman ought not to have moved that amendment so that pansexual then will stay in place of bisexual. I think that's what it means. Sam George suffered from some verbal diarrhea when he was going on and on. That's the reason. Let the chairman withdraw and then we'll move on.
Well, both are relevant to this issue. The definition of pansexual and that of bisexual are not alternatives. Then also the issue of our earlier decision, where we disagreed with the committee on the pansexual. that meant that this one shouldn't have been moved. Chairman, so you are being urged to withdraw your proposed amendment.
Accordingly withdrawn, Mr. Speaker. Thank you.
Honorable members, the proposed amendment for clause 6, Roman XVI is withdrawn. To an amendment proposed by Honorable Sam Nati George as XVII. Yes.
Right Honorable Speaker, I am guided to drop the proposed amendment at XVII and XVIII because I'm informed that the use of the word assigned is a term of act relative to determination of birth or sex at birth. So I'll drop both. Thank
Honorable
you.
members, the two proposed amendments are accordingly withdrawn. We now move to XVII. The numbering is not correct. We now go to the next proposed amendment, which stands in the name of the chairman of the committee, to subclause 2.
Mr. Speaker, subclause 2 of 6, amendment proposed, lines 5 and 6, delete not less than 3 years and not more than 5 years or both, and insert not more than 3 years. Mr. Speaker, the reasoning behind this is that at the committee, we agreed that the nature of the offense, whether it's a first-degree felony, second-degree felony, or a misdemeanor, and we wanted to be consistent as a misdemeanor, and that is the reason why we wouldn't want to go beyond 3 years. So that is the proposal of the committee, Mr. Speaker.
Yes, Majority Leader.
Mr. Speaker, whereas I may agree with the ceiling, there should be a floor. You cannot just say that it should not be more than 3 years. That will include a day's imprisonment. So let there be a floor. If it is 6 months or 1 year, not exceeding 3 years, I think it's reasonable. But to say that, to set the ceiling without a floor, it's a difficulty. I don't know whether because of the fine, whether we leave it to the draft persons to propose a floor. I think that will work.
Honorable members, I'm sure all of you are old enough to recall the case of 555. If you leave such things to the wide discretion of the presiding officers, it will say that because the charge she said 55, but not 555, that is inadequate. There's nothing like 55, and so the accused person was discharged. So we need to have a minimum and a maximum, or else they can say 1 hour. Yes, Chairman.
Mr. Speaker, I think that we need advice of the drafters on this. I think what the majority had suggested is apt, but it is inclusive of what I'm proposing. The only thing is that the judge would then have to decide on the nature of the offense and whether the judge would grant 6 months or 3 months or nothing at all. But to say the minimum is to say that by all means, You don't have to take any circumstances into consideration. The judge would have to commit any person, no matter the ingredients of what is brought before the judge. So I am comfortable if we make it not more than 3 years, but the minimum sentence is inclusive. So I would want to leave it either than that, because it's done. For
what is the minimum sentence? You say it's inclusive. What is it?
It is inclusive, but it is left with the judge. When you say not less than 3 years, and somebody wants it as a minimum to be 1 year, 6 months, or 2 years, it is inclusive of not more than 3 years. So the judge may rule on that.
So the judge can convict and say, go and sign a bond to be of good behavior. Will the purpose of the bill be achieved? Will the purpose of the bill be achieved in such circumstances?
Especially when we are battling as a committee, the purpose of the bill, I don't think that the proponents of this bill wanted people to be imprisoned at any cost. At some point, they even proposed that have the medical people to assist them for correction, so people may stop these practices, people who are engaged in that. And therefore, if we give the discretion to a judge, if anybody has shown remorseful, if the offense is not great, and the judge will say that go and sin no more, I think it is within the remits of the proponents of the law. And I think it's in order.
You know, in Ghana, somebody will come and tell you, I'm sorry. At the time he's telling you he's sorry, or she is sorry, she's smiling and laughing. Are you with me, Chairman? Yes. So when you say the person will show remorse, what kind of remorse? Somebody is saying, I'm sorry, but the person is laughing. So the person can come and just make the face, to use the common word, mobile, and you think that the person is showing remorse. Meanwhile, inside, the person is giggling. You know, if the purpose of the bill is not to commit any person to custodian sentence, let's say so, and then move out of that and be dealing with the other areas, either of fine or cautions or other things. But you have said 3 years. Which means you are talking about custodian. Yes, please.
Right, Honorable Speaker, I agree with the suggestion that we should have a minimum term sentence. And if you look at section 104, it does not necessarily spur a lower limit, but 103 does. And we are finding this, we are terming this offense to be a misdemeanor. In 103, it looks at indecent assault as a misdemeanor, and it carries a minimum of 6 months imprisonment. So there's a lower limit of 6 months for an equal offense of which is a misdemeanor. So if we are categorizing this as a misdemeanor, I believe that a 6 month minimum sentence and not more than 3 years would be in line with the sentencing regime.
I'm even not sure you want to categorize it as misdemeanor, because in what we are amending, you put it there, commits a second degree felony. 2. That's what is captured there. Yes, ranking member.
Mr. Speaker, let me draw the House attention to the fact that Section 104 of the Criminal Offences Act is not being amended. It talks about unnatural carnal knowledge, and it is punishable. So what we are doing at the committee level is to realign the sentencing regime so that we don't put the prosecution into an election where unnatural carnal knowledge, for instance, homosexuality, which is a crime under this law, and also a crime under Section 104. If Section 104 of the criminal offences has only the upper limit without the minimum limit, and this one has a minimum limit, what will happen is that when that offence is committed, then the prosecution will now be put into an election whether to prosecute under the law that can give the person a minimum sentence depending upon who is involved, or to come under this new law that sets the minimum limit to 6 months. I think that was the decision that informed the committee setting the upper limit. I do not have the Criminal Offences Act before me to be able to come out with a sentencing regime for unnatural carnal knowledge in Section 104 of the Criminal and Other Offences Act.
Yes.
Mr. Speaker, I listened to the chairman of the committee, and in his own words, he has structured his argument, and I believe that he should abandon it for a more superior argument advised by the Honorable Majority Leader. Mr. Speaker, in his words, he said that the judge can decide between nothing or up to 3 years. The word nothing, you cannot assume that you want to punish somebody and you yourself use the word nothing. So what are you seeking to achieve? So if he's listening to himself well, there cannot be nothing. What the Majority Leader have suggested, you can go for 3 months or 6 months as the minimum. Then the maximum is 3 years. Then, Mr. Speaker, listening to him again, once the ingredients of the offense established, the judge will have to convict. So it is not for the judge to just look at evidence and say nothing. No, you are to establish the ingredients of what constitutes the crime. As required by the Constitution, you must define the crime with these ingredients. So, Chairman, having listened to you, I think you should accept a minimum of 3 months and then a maximum of 3 years. Then the judge can have the latitude between the minimum and the maximum to set a ceiling. But if we go with your own words that he can start from nothing, then you don't intend to deter making this custodial. Thank you, Mr. Speaker.
Majority Leader.
Mr. Speaker, I was just going to say further to what the member for Tamale South has just said. In the prescription for a fine, there's a lower limit. Why is it that there, in talking about a fine, you're not talking just about the upper limit? As there's a minimum and a maximum. So commensurately, we should have that in the sentencing regime. And that is why I was saying that we could leave it to our drafters to do what is appropriate. Somebody is proposing 3 months, maybe 6 months, commensurate. So let's leave with the drafters to assist in the defining the minimum regime, either 3 months or 6 months, depending on what is provided here. Is a conviction to a fine of not less than 750 penalty units. 750 penalty units. What does it translate to? Is it 3 months or 6 months? I'm not able to say that from the top of my head. Let them help us to do that, and then we move on.
They just given me the Criminal Offences Act 1960 and 104, which is what you are referring to. It talks about unnatural carnal knowledge. And 104 subsection 1 says, a person who has unnatural carnal knowledge, A, of another person of not less than years of age, without the consent of that other person, commits a first-degree felony and is liable on conviction to a term of imprisonment of not less than 5 years and not more than 25 years. or B, of another person of not less than 16 years of age with the consent of that other person commits a misdemeanor, or C, of an animal commits a misdemeanor. So now the issue raised by the ranking member is that if we differ from this position, now we're creating another law which will give the opportunity to prosecutors to have a choice whether to prosecute under Criminal Offences Act 1960 or under the proper Promotion of Human Sexual Rights and Ghanaian Family Values Act. Now the option is for the one handling the case. And that's what he wants us to prevent by going with the current position of Act 29. Which is preferable? Yes, the Dafimako.
Speaker, this provision relates to the particular offense of unnatural carnal knowledge.
Yes.
But the law we are considering is much more expansive than this specific offense as captured under 104. So, in support of the ranking member's proposition, I think that we can also enhance the penal regime under 29 by including the opportunity for even the judge to even caution a convicted person, depending on the circumstances of the case. Because cautioning and discharging after conviction is also part of the sentencing. It's also part of the sentencing regime that we have. So I don't think that the genre of the offenses that we are anticipating under this legislation, it goes beyond unnatural carnal knowledge. Even conduct that is prescribed, you can be cautioned by the courts. The court should be able to have the opportunity.
The issue that is raised is one of granting an option to the prosecutor.
Yes.
Either to prosecute under the Criminal Offences Act
or under this
legislation.
Yes. Mr. Speaker, what they do is that sometimes they can combine the legislations in preparing the charge sheets. They can combine several legislations to levy the charges. So,
but as a defense counsel, do you find yourself being comfortable to allow prosecutors to fish around?
No, Speaker, they don't fish around. Okay.
I'm not saying they don't do it. I'm not saying they don't do it. I say as a counsel, as a defense counsel, do you feel comfortable when your client is faced with such a situation?
Mr. Speaker, you may not be comfortable, but that is where you bring industry to bear on the work. So,
I don't encourage jurisdictions where you investigate somebody and then prosecute the person and make allegations of 100 and something counts. I don't encourage that kind of thing. So that if 100 and something fails, at least one will get through. And you go fishing. Yes, Chairman, you were on your feet.
Yeah, Mr. Speaker, thank you. Mr. Speaker, I will not depart from what my ranking member has said. But, Mr. Speaker, I hold the original appeal that was filed in this House. Even though we run to the wall under clauses 19 to 23, This is what the proponents have as part of the memorandum to the bill. Clauses 19 to 23 deal with the protection and support for victims, accused, and other persons. These provisions are included as a recognition of the distinction between lifestyle activists and persons who engage in the acts prohibited by the bill as a result of social, cultural, financial, medical, psychological, or biological reasons. This is in recognition that as minorities, these persons the support, protection, and love of the majority to help them overcome their vulnerabilities and to give them options so they may be helped. It's only this portion I want to read. But Mr. Speaker, in course of a consideration, this is what I already informed members that we needed to iron out this. And most of the religious bodies were supporting the fact that they would give people who are prepared to go through reforms the opportunity to go through. If we make a strict law that if you are found guilty or you practice in this, you don't have an option. Mr. Speaker, we don't have a community service. That would have been severer than giving the person a custodial sentence, because the society would look down upon you. But to caution you or to give you a day's imprisonment or 1 month imprisonment, if we leave it to the discretion of the judge, they are also members of the society, they are learned, and depending on the circumstances. And that's why I am comfortable if we give the upper limit without saying that the person must be imprisoned as the minimum requirement. At any rate,
Chairman, I think it's okay. You've done your job. I seem to be convinced by the latest submissions. The intention is not to impose punitive sanctions, imprisonment and the rest, but to also leave room for restoration, curative, and some other measures that could heal maybe unfortunate people that might have been caught in these things. So please, let's still go by the existing law of not giving a minimum, but just giving the upper limit as proposed. Yes, ranking member, but you take the decision, not me. I'm just guiding you.
Yes, Mr. Speaker, with what you read to us on having a natural carnal knowledge, it has a minimum and a maximum.
They are different categories.
But
Mr.
Speaker, for instance,
I can read it for you again.
Bestiality is captured as a natural carnal knowledge. We are saying if you sleep with an animal, you are committing an offense, which is the same as the bestiality. So practically, when such a thing happens, are you coming under the current law or the Criminal Offences Act? Because the sanction regimes are different. Because we are not amending the Criminal Offences Act in section 104.
But 104 is very clear.
Yes.
You see, it gives categories. A person who has unnatural carnal knowledge, A, of another person, of no less than 16 years of age, without the consent. That's the first category. The second is with consent. And then the third is animal. Yes. So when you look at the clause we are dealing with, the clause we are dealing with,
yes,
is talking about sanctioning. And it talks about paragraph A, B, C, D, E, F, and G. So you go and look at what that thing is referring to, those clauses are referring to. It's not the same as in 104.
Mr. Speaker, having sexual intercourse with person of the same sex, assuming with consent, won't it come under section 104?
It will. Yes.
It will come under section 104. Yes. And now, this is one of the offenses that the punishment is being created.
Yes.
Now, 2, having sexual intercourse with an animal, which is bestiality, will also come under section 104. However, the sanctions being created in this law is going to be different from the sanctions created under section 104. Yeah. That is what will put the prosecutors into an election.
Yes.
Which we must avoid.
Yes, but that's why I say I agree with your submission.
That is so.
But I don't take the decision. It's you who take the decision.
Very well.
We should not create a different regime.
Very well.
We should go by the existing law.
Existing regime.
Yes, that's what I stated. Honourable members, I put the question. Be clear on what?
Respectfully, Mr. Speaker, if you say we should go with the existing legislation, would that be to say that we are aligning with the existing punishment in section 104?
Yes.
So then that would then automatically change and alter what we are discussing in 6.2 here. Because then we'll be aligning the sanctions in 6.2 to section. So, but there is no amendment to that effect before the House.
Oh, we are at the consideration stage. They propose an amendment, and during the course of the discussion, the House could decide to include all the concerns raised, and then I will read it out as the new rendition, and then you take the decision. Yes, please, Majority Leader.
Mr. Speaker, my difficulty is this. You see, in the Interpretation Act, we have commensurate, offenses, and then the sanction regime, the penalty. If it's a fine, it translates into some imprisonment. Now we have a minimum here. The minimum is 750 penalty units. What does it translate to? Into custodial sentence, because it's part of the Interpretation Act. Which is why I'm saying that let's leave it to the drafters, so that they can do the commensurate adjustment for us. That's how it should be done. But to leave it and say that let's create the upper ceiling without the minimum, I have a difficulty. So let's leave it to the drafters.
They don't have that difficulty, because there's a law we passed where you have penalty units. There's a correspondence custodian sentence. So that is there. It's already the existing law. But I was even wondering whether we should have those penalty units. Yes, please.
Right, Honourable Speaker, if I see what is happening here, if you look at the punishment regime in 104, it regards it either as a fee or a misdemeanor. Now, with the engagement we have and the intentment not to be only punitive but restorative, the question arose that if you use the first degree felony, which is what is in 104, you are looking at a minimum of 5 years and a maximum of 25 years, which appear to be too high-handed if you were also looking at restorative. If you were looking at only misdemeanor, that also appeared to be too lenient, not to act as a deterrent. And that is why we suggested a second degree felony, which is not in 104, which then sits in between the misdemeanor and the first degree. And that's why we suggested that the maximum should be 5 years, 3 years. But I agree with the position of the Majority Leader that in that case, we should then get an advice on what the minimum penalty of 750 units is concurrent with. Is it 3 months or 6 months? So that we have a lower limit also for custodial sentence. Is it a minimum of...
We don't need it because there's already a law on that. We don't need it. There's an existing law on the equivalence of penalty units. So that will apply.
Very well. I'm guided, right now.
Because we've not amended that. Please. Well, if it's the pleasure of the House, I would defer putting the question on that and leave it with the draft person to capture it. The position now is that usually before we go through the third reading, they will have compiled our decisions, brought it to us. We'll go through to make sure that our decisions are really captured before we do the third reading. And so there should be no fear. In fact, the procedure that has been adopted throughout has not been fair to the House and even the Speaker. Usually after we pass a bill, the draft person will go to compile the decisions of the House. And then it is passed through the clerk. And straight from the clerk are what has been captured by the draft person. And so we have that challenge, and we need to look at that procedure, which is captured, I think, in the Interpretation Act and our own rules. We have to look at it and revise it, because it should come to the House in the form of the third reading. Then after that, when it's compiled, the Speaker should have the opportunity to go through it. In any case, correspondence between this House and His Excellency the President is through the Speaker and not any other person. But this is what has been happening. So some of these things, when they call me, it's just a surprise. All those things to make sure that we sanitize the process and procedures on communication between Parliament and the other arms of government and constitutional commissions. With this, we defer question on it and we refer it to the draft person for the appropriate rendition. Honourable members, we move to the next proposed amendment, standing in the name of the chairman. That is page 32, clause 6, is numbered wrongly there as XVIII. Chairman, I wanted to finish the decision on clause 6.
Then Speaker,
yes.
Sub-clause 3, delete and insert the following. Mr. Speaker, it's more than 3 lines, more than 4 lines, but I'll read. For the avoidance of doubt, unnatural carnal knowledge referred to in subsection 2 of section 104 includes A, sexual intercourse between and among persons of the same sex; B, sexual intercourse between a man and an animal, or a woman and an animal; or sexual intercourse between a man and an inanimate object, or a woman and an inanimate object. In view of the amendment that was moved and agreed on by the leader of the House, Mr. Speaker, if the B, it could help to couch the B along the line that he proposed, I'll be comfortable. I so move, Mr. Speaker.
Well, honourable members, I think it's better to also leave this to a draft person. In view of the fact that there have been earlier amendments, she should take that in consideration to amend this clause, and then we can do further consideration on it. Yes, please.
Speaker, thank you very much. Speaker, in addition to referring this to the drafters to tidy up, if they can, after section 104, add of Act 29, Because Section 104 of what? It has to be of Act 29. Includes blah, blah, blah. Yes. Thank you very much.
Thank you. Yes, please.
Mr. Speaker, I have, and I think we raised this when the committee was considering it, that the proposed amendment in 3C may create unintended consequences, because sexual intercourse between a man and an inanimate object or a woman and an inanimate object would necessarily include sexual intercourse with all manner of aids that couples use to enhance the sexual experience. And I'm not sure if that's what the intention of this bill is. It would necessarily include sex toys and other aids that couples, heterosexual couples, also use to enhance the sexual experience. So if that is what the House intends, then we have to be clear in our minds that we may be criminalizing activity which may not necessarily be limited to only those LGBTQI community that's the target of this bill is. But it may also be targeting straight couples who use sex enhancement tools to enhance their sexual experience. So we need to be mindful of what the unintended consequence 3C could be. And I'd propose that 3C be deleted from this amendment. Thank you.
Honorable Minister, we had earlier on extensively discussed that issue in an earlier clause, and I took a position on it. And so that will guide the draft person in recapturing this matter. So I refer it once again to the draft person to take that into consideration. Yes, Majority Leader.
Mr. Speaker, further to what illumination that you have provided, the three that is being sought to be deleted for the insertion of what the chairman is proposing. Mr. Speaker, it's not come up for mention in 6. 6 is in respect of sexual intercourse. Now you want to use this legislation to define unnatural carnal knowledge. I don't understand. I don't understand. 6 is talking about sexual intercourse, and 3 seeks to define what sexual intercourse used under 6 means. But now you are saying that we should delete it, and now you seek to give a new meaning to unnatural carnal knowledge, which is not been mentioned in 6. I don't know the purpose of this amendment that the committee is proposing. I do not. If there's anything that we can do to really tidy up the 3, that should be our concern.
Well, yes, Sam George.
Mr. Speaker, I think at the point the majority leader has raised, fundamental, and that is the confusion that at times has occasioned what the Minister for Communication said about heterosexuals. Because this interpretation of sexual intercourse here is relative to just Section 6 or Clause 6 in the bill. And so it seeks to define sexual intercourse as is used in Clause 6 of this bill. And we've done that in 6(1)(a) already, as sex between a person of the same sex, sexual intercourse between persons of the same sex, sexual intercourse with an animal, or pansexual activity. So that is the confines within which we are defining sexual intercourse. So it should not be expanded to mean all sexual intercourse. So we need to tidy up again how the introduction to that is done. Maybe with the drafters we can do that, right, Honorable Speaker.
Exactly so. So the things stand referred to the draft person for a better rendition for the consideration of the House. We take the last but one, proposed amendment to Clause 6. It stands in the name of the Honorable Majority Leader. Please, you may move your proposed amendment on sub-clause 3.
Mr. Speaker, I think this is equal to what I just said, because C is talking about a person, for purposes of this section, sexual intercourse occurs where a person by use of so and so a man's male organ or any other object or contraption penetrates the anus. And I thought we should include the female sex organ. I thought we should include the female sex organ.
Why are you running away from reading it? But, honorable members, the proposed amendment to subclause 3, paragraph C. Subclause 3, paragraph C, if a person, by use of the penis of the person or any other object or contraption, penetrates the anus or other bodily opening of an animal. And so his proposed amendment is for us to insert vagina.
Right, Honorable Speaker, respectfully, before we can do that, we need to settle the matter of the previous amendment. Because if the previous amendment is going to the drafters, then we cannot be proceeding with his amendment. But if we are dropping the previous amendment, which I am obliged to, then we can take his amendment and do same. Because what he's amending is completely different from what we were referring to the drafters to go and work on.
So we'll refer it to the draft person?
Yes.
After the rendition, they will know which appropriate decision to put. We take the last one. The last proposed amendment, I think it's couched about the same, but I'll permit him to move it. Then we can do the referral.
Yes, Mr. Speaker, because I just saw that for 3, we have neglected to include where a woman has sex with an animal. That is not covered in the entire 3. That is in the definition of sexual intercourse. So,
honorable members,
so we can ferry everything to the.
We are referring it. We defer the questions on the last 4 proposed amendment to clause 6 at page 32 to the draft person to tidy up and then come back to the House again. With this, honorable members, I will proceed to suspend sitting for 30 minutes. 30 minutes. Suspend sitting for 30 minutes. Honorable members, we have a lot of work to do. And so, before he was engaged somewhere, he wasn't visible. So I've now identified him. So second deputy speaker to take the chair. And they brought.
Yes. Leader.
Speaker, at the commencement of public business, item 6.
Hold on. I think we have come to the end of the consideration stage. So.
Speaker,
Yes.
at the commencement of public business, may we take item 6BI? Speaker, we are limiting ourselves to 6BI.
Honorable members, come with me to page 3. Page 3, item listed 6. 6B. So 6BI by the chairman of the committee.
Report of the Committee on Food, Agriculture and Cocoa Affairs on the annual budget estimate of the Ministry of Fisheries and Aquaculture Development for the year ending 31st December 2024.
Honorable members, the report has been duly presented. It is for distribution to honorable members. Yes.
Speaker, may we proceed to page 11 of today's order paper, page 11, and take item 10. And Speaker, let me seek your leave for it to be done by the Deputy AG.
Is it item 11?
No, page 11, item 10.
Yes.
Mr. Speaker,
Honorable Chairman, hold on. Yes, leader.
Mr. Speaker, I don't have any much objection to that. But once again, my majority whip is making an application for the Deputy Attorney General to do the business. And we are saying that it is becoming a habit that the Attorney General himself will never turn up in the House to do businesses like this. We don't have any problem with the Deputy Attorney General, but the Deputy Attorney General is deputy. The substantive minister exists, and the majority side don't even bother to tell us where the Attorney General is. He just gets up and says that the deputy is here to do business. Tell us where the Attorney General is. Why consistently he doesn't find it necessary to come to Parliament to do his own business? Tell us.
Speaker, my colleague knows today has been a very smooth day. Don't start anything that cannot be sustained. And besides the point, Attorney General has always been to this House to do business. No, our question is not part of his business. Anytime he's scheduled to answer questions, he's been there. Speaker, my colleague should just exercise restraint. In any case, I communicated with you, and we've been communicating. Kwame, don't do this. We spoke. You are a friendly man, very friendly. Speaker, he understands. The Attorney General is out of jurisdiction, and early morning, he's returning soon. Speaker, I spoke to him. I communicated duly to him. So please, Speaker, he understands. There is certainly no problem. We can progress. Let's progress.
Yes, Honorable Aini.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to support my chief whip on this matter. Mr. Speaker, what is good for the gander is also good for the goose. I remember when I was Deputy Attorney General, anytime I was on this floor to do business on behalf of the Attorney General, it was the then minority leader. The then minority leader.
Is he in the room?
The Swami Mercy, the Honorable Member of Parliament for Swami, and the current majority leader, who used to object to my doing business on behalf of the Attorney General. And I remember, distinctly that he and Honorable Ben Kumbo would argue for 15-20 minutes on this floor, just so that I would be allowed to do business on behalf of the Attorney General. And one message that he gave always was that the Attorney General was not respecting Parliament. Today is the Attorney General respecting Parliament by always sending the Deputy Attorney General to the House. So, Mr. Majority Leader, please call the Attorney General to come and do business here, so that it will show respect to the House of Parliament. Thank you.
Yes, honorable members, at least for today. Next time we will ensure that the Attorney General himself can. But for today, I'm interceding. Let's allow the deputy.
Thank you very much. Thank you very much for the bailout. Except to say to the former Deputy Attorney General that he's a yesterday man. Mr. Speaker, he keeps describing me as a minority leader. he's a yesterday man.
Yes. So, Deputy Attorney General, you may do so for and on behalf of your minister.
Thank you very much, Mr. Speaker. And before I move this motion, I would like to place on record that the Honorable Attorney General, Godfrey Yeboadame, does not take lightly proceedings at this August House. Unfortunately, he's had to leave the country to attend the conference on corruption, and so has delegated me to be here. This is not in any way to suggest that the Attorney General does not take Indeed, Mr. Speaker, the Attorney General is here the coming week to answer, I believe, 6 questions that have been tabled by members of this Parliament, and so I believe we'll be here at that point. That said, Mr. Speaker, respectfully, I move in terms of item number 10 at page 11 of the motion paper. Oh, sorry, of the order paper. I move accordingly, Mr. Speaker.
Yes, honourable members, the motion has been moved. Chairman of the committee.
Mr. Speaker, I beg to second the motion, and in so doing, Mr. Speaker, I present your committee's report. Mr. Speaker, I pray that the Hansa Department captures the report in its entirety whilst I read the conclusion. And Mr. Speaker, after carefully studying the estimates of the sector, the committee is satisfied that their programs outlined for the year would go a long way to strengthen the provision of the aid. The committee recommends to the House to adopt this report and approve the total sum of 33,424,200. Sorry, Mr. Speaker. Mr. Speaker, to approve the amount of Mr. Speaker, sorry. There was a correction that was made, so I'm sorry. To approve the total sum of 149,005,669 for the services of the Office of the Special Prosecutor for the year ending 31st December 2024. Mr. Speaker, I so move. Thank you.
Thank you very much. Honourable members, the motion has been moved and it has been seconded. It is now before the House. Yes. Honourable Ranking Member for Constitutional.
Mr. Speaker, thank you very much for giving me the opportunity to contribute to the motion, item numbered 10, that this Honourable House approves the sum of 149,569 Ghana cedis for the services of the Office of the Special Prosecutor for the year ending 31st December 2024. Mr. Speaker, I must place on record that when the report of the committee is laid, before the motion is moved, the report of the committee must be distributed to all members. Mr. Speaker, all members do not have adequate copies. I was sitting in the House less than 2 minutes ago. That chairman walks to me with copies of the report, and they are moving a motion. They are moving a motion for us to take this particular report. What opportunity is then given to me to go through the report? Mr. Speaker, this is not the best. Mr. Speaker, they brought the report, withdrew the report in the next seconds, and now we are doing this. Mr. Speaker, I am placing this on record that next time, if the report is not adequately distributed, then the motion should not be moved. If I ask this House, how many members have the report that we are taking? The overwhelming majority do not have. Then it means that you are distributing the report to your side and you are not distributing it to our side.
Adequately.
Mr. Speaker, we know kangaroo laying, but the report, we need to have the report in 10. Mr. Speaker, as indicated,
Is it Ranking? Today you are fighting with your chairman.
Mr. Speaker, I'm not. Mr. Speaker, I'm not. I'm just placing a factual record.
Fine. Let
camera.
Hold on. Let me listen to you.
The camera have seen the chairman walking to me a few minutes ago.
Out of respect, my friend complained a moment ago that his report was withdrawn, and that was the report for the Ministry of Parliamentary Affairs, because I gave it to the minister, and when he went through, he needed to make an input. So I had already, the report was distributed, and then that was withdrawn, but he said that when the later one was substituted, he had not gotten a copy. So I went to the clerk at Table's office and got a copy, and I myself presented it to him. So it is not even on this estimate that should have been withdrawn. If it was withdrawn, that was a mistake. So my colleague should take it in good faith, that I acted in good faith so he could get one report, and it was a minor correction with the Ministry of Parliamentary Affairs, which we haven't moved yet. So if any report was withdrawn from you, it was inadvertently done, and the correct one had been given to you by me. So please proceed.
Ranking, proceed.
Mr. Speaker, this very report that I'm
don't go into that issue, Honorable Anyafo.
A few minutes ago.
Honorable Anyafo, don't go into that issue, because I don't even think it's the duty of the chair of the committees that are responsible for the distribution of the, it's the clerks that are supposed to do that. So at least per his explanation,
Mr. Speaker,
by courtesy,
with all due respect, I am not accusing the chairman of the committee, but the practice is that before a motion is moved, there must be adequate copies of the report distributed to members.
Well noted.
As a working member, I'm having a copy 2 minutes ago. What happened to other members?
Honorable Hiafo, well noted. So,
As a member, I don't have a copy.
Honorable Hiafo, let's hear you.
Mr. Speaker, in contributing to the motion, I refer to paragraph 10.1, talking about inadequate budgetary allocations. Mr. Speaker, I believe strongly because of the inadequate budgetary allocation, that is why in the year under review, the Office of the Special Prosecutor has been giving additional amount in the sum of 62 million Ghana cedis. Mr. Speaker, the 62 million Ghana cedis is made up of 25 million Ghana cedis for capital expenditure and 37,500,000 for goods and services. Mr. Speaker, as the ranking member of the committee, as to whether these amounts have been used to procure the vehicle under reference, I cannot tell, Mr. Speaker. Mr. Speaker, paragraph 10.5 is also stating that there is the need for institutional support for the Office of the Special Prosecutor. Mr. Speaker, this House has established the Office of the Special Prosecutor tasked with the responsibility of investigating all corruption cases and corruption-related cases, prosecuting all corruption and corruption-related cases, and taking steps to prevent corruption and corruption-related cases. Mr. Speaker, I agree that the Office of the Special Prosecutor will not be able to do this unless there is an institutional support. All institutions must come together to support the Office of the Special Prosecutor. I believe strongly because the Office of the Special Prosecutor is not getting the institutional support, he had to do a press conference to say that is Ankwa Noma Odinikra Abo Afore is working along. He's sacrificing his life. So, Mr. Speaker, I'm using this particular opportunity to indicate clearly that the Special Prosecutor needs the institutional support if, as a country, we want to fight corruption, prosecute corruption, and take steps to prevent corruption. Some are even of the view that the new Special Prosecutor is also being frustrated from performing his duty and his statement in tree.
Honorable Rankin, hold on.
Very well.
Yes, leader.
Mr. Speaker, I heard my honorable friend on the other side, who is on his feet, relate to some lyrics in the song. And he says to us, if I heard him correct, Ankwa Noma, or the crab for if I heard him. Mr. Speaker, may I refer him to Order 47, which provides that the proceedings of Parliament shall ordinarily be conducted in English language, except that a member may exercise the option to address the House in either Akan, Nzimaga, Ewe, Hausa, Tabani, Nagari, or in any other local language, provided facilities exist in the House for its interpretation. The Speaker, he should translate it to us. The Speaker, and that is the convention. If it cannot be translated, he then undertakes to do the translation for us. Sure.
Mr. Speaker, may you help me appoint Dr. Memesi to do the translation in Akan?
You have the facility.
Mr. Speaker, he's literally.
But what you said was right.
Yes.
Yes.
He's a bed that works alone. So as a special prosecutor, he is now alone in the business of trying to prevent corruption and corruption-related offenses. Mr. Speaker, if you listen to him, you can come to a conclusion that this is a statement made out of frustration. Mr. Speaker, do we want a young man, 43 years, removed from the lecture theater and the courtroom and appointed as a special prosecutor to also resign as a result of frustration? I believe that the first special prosecutor that we have appointed similarly resigned, and after resignation, he indicated that the President of the Republic of Ghana, Nana Akufo-Addo, is a mother serpent for corruption.
Honorable Hiafo, yes, withdraw that. Yes, withdraw that bit, please.
Mr. Speaker,
yes, withdraw. No.
If the special prosecutor is crying for institutional support,
Honorable Hiafo, please. I mean, yes, withdraw that. Yes, withdraw from you. Yes, do that for me.
For you?
Yes, withdraw it from me.
Very well. Mr. Speaker, if for you, the statement is withdrawn.
If you have you withdrawn?
Yes.
Table, just expunge that portion from it.
They are allergic to mother serpent of corruption.
Yes, Mr. Speaker is allergic to mother serpent for corruption.
God is in the press. You can go and withdraw it from them.
Mr. Speaker, so what I'm putting on record is that, Mr. Speaker, I have withdrawn the statement made by Martin Amidu that His Excellency Nana Akufo-Addo is a mother serpent for corruption. Mr. Speaker, so my plea is that corruption affects everybody. Therefore, the office of the special prosecutor needed all institutions to support him in order to perform his functions creditably. Mr. Speaker, with these few words, I support the motion.
Yes. I'll go to Honorable Communication Minister.
Thank you, Mr. Speaker. Mr. Speaker, as long-standing members of this House, I'm sure we are all aware of the annual budget ritual where all ministries, departments, and agencies decry the fact that despite their budget needs, almost invariably, they never get sufficient resources to enable them prosecute their mandate. Every agency, ministry, or department that appears before the committees of the House, including the Constitutional, Legal, and Parliamentary Affairs Committee, faces that situation. So I'm very surprised that the ranking member will seek to intimate that the budget allocation to the special prosecutor, which is less than what he has requested, is as a result of government's lack of commitment to fighting corruption. I don't think that that can ever be the situation, because every ministry, department, or agency that appears before this House suffers from that same situation. Mr. Speaker, at page 9 of the committee's report.
Are you challenging the Speaker?
At page 9.
I'm not challenging the Speaker, but that.
The Speaker says you should sit down.
She made reference to a ranking member. That is why I'm on my feet, Mr. Speaker.
At page 9 of the committee's report, the committee acknowledges.
Honorable, just hold on. Yeah, Rankin, let me hear you.
Mr. Speaker, in speaking, I made reference to paragraph 10.1 of the report of the committee that the Minister of Communication is also holding. And Mr. Speaker, the marginal note of that particular report is inadequate budgetary allocation. So for the Minister to say that I am saying it as a ranking member is wrong. Mr. Speaker, I indicated that the report made reference to this. It is as a result of that, that in the year under review, they were given additional 62 million Ghana cedis. And it's a factual statement.
Well noted. Nana, continue. Honorable.
So I didn't say the lack of government ability or whatever she's saying. That is a figment of your own imagination.
I am not quoting you verbatim. I am paraphrasing what you said to the hearing of every member of this House. That it is government's lack of commitment to fighting corruption and supporting the Special Prosecutor's Office that has resulted in him getting inadequate budgetary allocation. That is not a factual statement, and I have to put that on the record. Mr. Speaker, the committee itself acknowledges the need to adequately furnish the Office of the Special Prosecutor with the needed resources towards its full operationalization. However, the committee also pointed out to the Office of the Special Prosecutor that there is the need for it to show commensurate concrete gains made to the state by its existence, because the state has been funding its existence throughout, and yet we have very little to show for it. So it also needs to let the state know that it is getting some returns on its investment. Even though members appreciate the challenges he's facing, but they also bemoan the fact that the office is yet to live up to the hype which ushered in its establishment. It's important that all of us learn to do a lot more with the little resources that we're given. And so, despite the fact that he's not getting everything that he wants, he needs to demonstrate that with the little that he has received, which is much more than many other government institutions receive, we are also deriving the benefits that the state expects from the establishment of its office, and it is not just a hype. Mr. Speaker, we don't appreciate the challenges that government institutions are going through. We're all working under very, very limited budgets, but despite that, we're showing results. So it's incumbent on the Special Prosecutor to also demonstrate the faith that the people of Ghana have placed in his office and assist us to adequately fight the canker of corruption, which we all know is as old as Adam. I thank you, Mr. Speaker.
Yes. Honorable Dafiamapo.
Speaker, thank you for the opportunity. Mr. Speaker, let me add my voice in respect of the adoption of the motion ably moved by the chairman of the committee and ably moved by the Deputy Attorney General and seconded by the chairman of the committee. Mr. Speaker, I am happy about one thing, and that is that even though the inadequacies of resource allocation to the Office of the Special Prosecutor was identified by the committee, the evidence is that in the course of the year, the Office of the Special Prosecutor actually got additional support from the Office of the Finance Ministry, which, Mr. Speaker, if you look at page 5 of the report under financial performance, the committee had this to say. In the 2023 fiscal year, the OSP was allocated an amount of 129,529,380 Ghana cedis. During the mid-year budget review, Mr. Speaker, the initial allocation was revised to an amount of 149,549,380 Ghana cedis. The committee also observed that an additional budget support of 62,500,000 Ghana cedis, made up of 37,005,000 Ghana cedis for goods and services, and 25 million Ghana cedis for capital expenditure was allocated to the OSP in the course of the year. Mr. Speaker, this brought the total allocation and actual releases to the Office of the Special Prosecutor in excess of 212 million. Mr. Speaker, I align with the position of the Honorable Minister for Communications and Digitalization that once resources are being made available to the Office of the Special Prosecutor, the generality of the people expect some results. And Mr. Speaker, of course, in delivering these results, the Office of the Special Prosecutor also requires cooperation from other state institutions. And so it's important that other state institutions and organs of states cooperate with him to deliver on his mandate. Mr. Speaker, let me conclude by highlighting some of the things the OSP indicated to the committee to focus on for 2024. Mr. Speaker, at page 7 of the report, the OSP intends to recruit 50 specialized staff. The OSP intends to train 200 staff on the rudiments of intelligence gathering. The OSP further intends to procure security intelligence and communication equipment, and also procure cyber security equipment, as well as investigate about 50 cases. Further, the OSP intends to file 10 corruption cases in various calls and recover about 5 assets. It further intends to procure office furniture, but I don't think that procurement of office furniture should be an outlook for the Office of the Special Prosecutor. These are mundane administrative things. And so, Mr. Speaker, with these words, I support the call for the motion to be adopted. Mr. Speaker, save some couple of corrections of the report at page 11 under paragraph 10.5. Mr. Chairman, under line 2, it reads, against corruption and corruption-related offenses. So, under line 1, it should be the Office of the Special Prosecutor, as indicated, is to promote. The ace is missing there. And then, when it comes to, despite this laudable initiative of the government, the committee observed after deep-throated interaction. Mr. Speaker, this is a House of Records. I don't know how the committee interacted in a deep-throated manner with the Office of the Special Prosecutor. So I think that should be properly couched. Mr. Speaker, with these words, I support the call for the motion to be adopted. Thank you very much.
Thank you. Honourable members, at the conclusion of the debate, okay, let me take the leadership. Honourable Champon, next, you have other ones, then I'll give you the opportunity.
Thank you.
I'll give you the opportunity, the other ones we will take. Yes, Honourable Minority Deputy Whip.
Thank you, Mr. Speaker, for the opportunity. Mr. Speaker, I rise to support the motion, and in doing so, I will make some few comments. Mr. Speaker, we must commend the Office of the Special Prosecutor for doing a very good job. This is one of the best things that we have done unto us ourselves as a country. Mr. Speaker, many people in the country now, even though some are lamenting, have some kind of confidence in him. Those days, it used to be only Public Accounts Committee. And before Public Accounts Committee will get to the report of corruption cases, Mr. Speaker, years have gone by. But going through the report that has been submitted by this committee, and Mr. Speaker, paragraph 8.1, operational performance, the OSP said that the OSP was able to record the following achievements in the year under review. Concluded a major recruitment effort in bringing on board 239 personnel. Then the second one is the office initiated legal proceedings against 7 individuals, including a former minister, a CEO, and 2 deputies, a district chief executive nominee, public servants, and private individuals who stand accused of various corruption and corruption-related issues. Mr. Speaker, this time, while Public Accounts Committee is fighting old cases, the Special Prosecutor is fighting new cases. And I think this is the best way, Mr. Speaker, to fight corruption. Therefore, going about the plea of the committee to make sure that the needed resources be made available to the Office of the Special Prosecutor to do his work is in the right direction. Mr. Speaker, with these few achievements, the Special Prosecutor is saying that he's going to investigate 50 cases of corruption and to recover 5 assets and to file 10 corruption cases in various courts. So, Mr. Speaker, the 149 million, when you hear it, you think that it's a huge money that is being said. Mr. Speaker, the Special Prosecutor needs more money to do more. Where we have come to, the best way to protect this, our democracy, is to make sure that we strengthen anti-corruption institutions. If that is not done, Mr. Speaker, the future of this democracy, just others are saying, will be in serious jeopardy. Therefore, I thank and commend the Constitutional and Legal Committee for doing a good job. But I still want to appeal to the Minister for Finance that if there will be the need to do further supplementary budget somewhere, Mr. Speaker, I think that the Office of the Special Prosecutor must be reconsidered. With these few comments, Mr. Speaker, I once again want to support the motion for the approval of the 149 million for the Office of the Special Prosecutor. Thank you, Mr. Speaker, for the opportunity.
Yes, Honourable Deputy.
Mr. Speaker, I rise in support of the motion, and in doing so, Mr. Speaker, permit me to rely on the submissions of the honourable member who just spoke before me. Mr. Speaker, I agree with him when he submitted before the House that this is one of the good things we did as a country by setting up an independent institution to deal with issues of corruption. What is left is for us to support the institution to function. This statement, Mr. Speaker, is very profound, and I want to associate with it. Oftentimes we politicize such institutions, and eventually we make their work lame, and we don't get the desired results. I think that the 149 million allocated to this institution, though may not be sufficient, but it is an effort made by government, which is a higher amount as compared to previous. Many other institutions, departments and agencies are not getting this amount. Perhaps they will see it as an envious amount that has been allocated to this institution. For me, as a country, we should focus on dealing with issues of impunity all across the country. Mr. Speaker, we come here pretend all is well, but all is not well. And the so-called corruption is not limited to the so-called political class. The perception about corruption limited to the political class is what is really destroying the country. So, but we as a political class must rise up and get our people to appreciate the work we do and appreciate the need to hold high certain virtues so that things do not go bad for us to take responsibility. Everything in this country has become partisan and political. And for my respected colleague Bernard Ahiafo to even make reference to some other statement leaves so much to be desired. Because instead of focusing on the institution, we would want to run to town because of so-called partisan gains. These are not right. We should support the special prosecutor. This is the first time a government has boldly walked a political talk from the manifesto into bringing an enactment to give it the life that it needs. Let's encourage the special prosecutor to do its work. And Mr. Speaker, as a practitioner in our courts, I know that sometimes these law enforcement agencies get frustrated. But that is it. That is the law. I would want to encourage the special prosecutor never to give up. Mr. Speaker, only yesterday he was a practitioner. And as a defense counsel, he knows how he did his work to have his way for his client. So if today he is holding the other side of the stick, be strong, he should know that these are the things that go with it. I would want to encourage the office. I don't want to personalize it that it is Mr. Kisi Ejabin. It is the office. Rather, the office should strengthen itself with the limited resources that it gets, move through the court system, get the court to appreciate its work. If you lose at the High Court, you move into the Court of Appeal. You lose there, you go to the Supreme Court. Because, Mr. Speaker, without the court system helping the special prosecutor cannot achieve anything. So let's move away from the media-driven results that sometimes we may want and get the judicial results. And then also to encourage them to look at the law. If they need to come here for an amendment, we may have to look at it. And also look at what the Constitution says. In other jurisdictions, when you are talking about acquired wealth, the burden may be on you to explain how you acquired it because it is not commensurate with your known source of income. Our Constitution doesn't say so. Our Constitution provides an adversarial system where the person alleging must prove that indeed this was gotten through some criminal or illegal way. So, Mr. Speaker, that balance must not be lost on us, so that as a country we will know where we are moving towards. If we want to amend our constitution, we should be bold about it and say that we are amending it, and then the law would also impose a burden on you to prove that indeed you acquired it legally or illegally. But otherwise, we may be dealing with perception and be frustrating ourselves as we go along. Mr. Speaker, without more, let me thank the committee for a good job done and add my voice to the recommendation to the House and the invitation for us to adopt this report. I thank you, sir.
Very well. Honourable members, at the conclusion of the debate, all those in favour of the motion listed 10 in today's order paper say aye. All those against say no. Honourable members, the ayes have it. The motion listed 10 is hereby adopted, and that this House has approved the sum of 149,005,669 Ghana cedis for the services of the Office of the Special Prosecutor for the year ending 31st December 2024. Yes, Leader.
If Mr. Speaker will be pleased, may we proceed to motion 9.
So, honourable members, let's come back to page 10. Page 10, item listed 9. Page 10, item listed 9 by the Attorney General, so the Deputy Attorney General.
Respectfully, Mr. Speaker, once again, I move in terms of item number 9 at page 10 of the order paper. I so move accordingly.
Thank you, the Chair.
Thank you, Mr. Speaker. I second the motion ably moved by the Deputy Attorney General. In so doing, I present the committee's report. Mr. Speaker, I pray that the Hansa Department captures the report in its entirety whilst I read the conclusion to save time. Mr. Speaker, after carefully studying the estimates of the Legal Aid Commission, the committee is satisfied that the provision of the legal aid services to the people of Ghana. The committee recommends to the House to adopt its report and approve the total sum of 33,424,217 for the services of the Legal Aid Commission for the year ending 31st December 2024. Thank you, Mr. Speaker.
Chairman, do members have copies of the report?
Yes, Mr. Speaker, it's been circulated, and there are leftovers even at the...
The ranking is just standing that it doesn't have.
Mr. Speaker, clearly, I do not have the copy of the Legal Aid report of the Legal Aid Commission. So I don't know which member from our side has a copy of the Legal Aid Commission. So you also don't have. So what is happening? Majority leader doesn't have, and I believe minority too doesn't have, and I shouldn't, for instance, you. So let's just do the right thing.
But yes, I think it's making a fundamental issue. Not necessary to the chair of the table. I'll make a reference to the table. I mean, you know we are coming to take these reports, and you've advertised the report. So the report should be ready with members. So table, take note of that. I think we are taking it lightly, but I think it's something that we need to be serious about it. Yes.
Mr. Speaker, normally, even if the reports are shared, few copies are left with the table office, so that when the motion is to be moved, if you don't have it, then they serve you. I think we can marry the two, so that once they share the copies, few copies should be preserved at the two caucuses side.
Yes, Deputy.
Mr. Speaker, in view of the prevailing matters raised, we'll place this motion on ice and proceed to deal with item 11 on page 11. 11 on page 11.
Very well. So, but 11, do we have the report? We have the report for the 11. Okay, very well. So, leader, they said they have it.
Speaker, I rise to move that this Honorable House approves the sum of 9,432,774 Ghana cedis for the services of the Ministry of Parliamentary Affairs for the year ending 31st December 2024. Speaker, this amount has been allocated for the performance of the core functions of the ministry, and that includes initiating and formulating policies considering the needs and aspirations of the people, facilitating development planning in collaboration with the National Development Planning Commission, coordinating, monitoring and evaluating the efficiency and effectiveness of the performance of the sector, and facilitating the smooth conduct of government business on the floor of Parliament, and serving as the interface between the Executive and Parliament, providing effective linkage between Parliament, Executive, and Judiciary and the civil society organizations, facilitating citizen-centered interface involving the state and non-state actors, private businesses, CSOs, etc., on matters relating to the legislature, assessing policy papers, credit agreements, and legislative proposals and other matters intended for deliberation by Parliament, and providing appropriate recommendations. The Speaker, all this is in pursuit of the strategic objective of the ministry, including deepening democratic governance, deepening political and administrative decentralization, and improving participation of civil society in national development and promoting the fight against corruption and economic crimes. The Speaker, it is for this reason that the ministry approached the Ministry of Finance and sought for the allocation of an amount for the purposes of carrying out its functions in 2024 financial year. And pursuant to that, an amount of 9,423,774 Ghana cedis has been allocated to the discharge of its functions. So, Mr. Speaker, I so move. I thank you very much.
Thank you very much. Yes, Honorable Member for Asante Atem Central.
Mr. Speaker, before I proceed, I want to find out from my colleague if he has a copy of this report.
With motion 11. So I thought we were going to.
Yes, I hold in my hand a copy of the report, and I wanted to.
No, Honorable.
Mr. Speaker, I second the motion, and in so doing, Mr. Speaker, I present the committee's report. I pray, Mr. Speaker, that the Hazard Department captures the report in its entirety, and whilst I read the concluding aspects of the report. Mr. Speaker, the committee recommends to the House to adopt its report and approve the sum of 9,423,774 cedis for the programs and activities of the Ministry of Parliamentary Affairs for the year ending 31st December 2024. Thank you, Mr. Speaker.
Yes. Let him now come to Ranking.
Mr. Speaker, thank you very much for the opportunity to contribute to the motion that this Honorable House approves the sum of 9,432,774 cedis for the services of the Ministry of Parliamentary Affairs for the year 1st December 2024. Mr. Speaker, I look at page 5 of the report, table 1. Mr. Speaker, it is observable that what we have here is a revised budget. I stand to be educated. Mr. Speaker, I believe strongly that in the year under review, the 2023 budget was approved with Appropriation Act passed by this particular House, setting ceilings for the ministries, departments, and agencies, which translated into a total ceiling. Mr. Speaker, I am not aware that that particular budget has been revised by this House, let alone knowing whether revised appropriation has been passed. So is it a practice that when Appropriation Act is passed with ceilings to ministries, departments, and agencies, without this House approving a revised budget and passing Appropriation Act, we can have an estimate on a day like this, talking about a revised budget and taking away completely the allocation per the Appropriation Act passed by the House. The Speaker, I observed that that is translating through the ministries and their department estimates that they have brought before us this year. Mr. Speaker, this is a matter that has to be interpreted, whether or not, if the budget is not revised, whatever is given to the ministry as an additional fund should have a way of being treated, just like how budget was appropriated for the office of the special prosecutor, and we have a note indicating that additional 62 million has been given, and there was an indication as to where they have taken that particular money from, or if taking it from a special vote. We were told it's from other government obligations, and we are clear with it. But in this case, we are being told the budget has been revised. When? I'm not aware as member of Parliament. So, Speaker, we look at the budget relating to compensation, and we realize that it was underutilized. And we try knowing how come the budget was underutilized. The response was that they have given employment to some persons in the ministry who are above the age of 60 years. Because of that, the system is not admitting. Mr. Speaker, the law is clear that the compulsory retiring age is 60 years. So, under what circumstances are we employing persons above 60? Mr. Speaker, if it is contract, I believe the law allows it. So it would have gone through the system. But if it is employing somebody above the age of 60 years, it is then that you can have difficulty going through the system. We need to have a way of dealing with this particular issue for the impression not to be created that though the law sets the age limit, we are bending the law, going beyond it, employing people above 60 years. Mr. Speaker, we also realize that there has been increase in CAPEX budget estimates. We know, or we are told, that the committee, the ministry is engaged in a very serious work with committee that they have put in place to look at our constitutional review. I pray that these monies, if approved for the ministry, will really complete the issues relating to the review of our constitution and clearly bring it to this particular floor to be updated. Because as a lawyer, I agree that it's about time to look at reviewing our constitution. And since that is being championed by the Ministry of Parliamentary Affairs, Mr. Speaker, I support the motion and pray that the amount indicated be allocated to them. Mr. Speaker, thank you for the opportunity.
Yes, Honorable Champo.
Mr. Speaker, thank you very much for the opportunity to support the motion on the floor for the House to approve an amount of 9,423,774 Ghana cedis for Ministry of Parliamentary Affairs to undertake their internal projects in 2024. Mr. Speaker, if you look at the expenditure outline for 2023, Mr. Speaker, this is what I wanted to raise, but I did not get the opportunity to talk about it. If you look at their compensation budget, the revised amount stands at 3.564780 Ghana cedis. 21,53439 was released to them, and they spent exactly that same amount. This is what I wanted to see with the first report that we were talking about in Office of Special Prosecutor. I will let it because going forward, similar issues may come up. If you look at their report, Mr. Speaker, the revised budget for the office was 68.9 million Ghana cedis. The amount released to them, 12,297,284 in respect of compensation. And they are reporting to the House, Office of Special Prosecutor. No, I'm relating it to your report. I'm speaking good for you, don't worry. Mr. Speaker, they are telling us that out of the 12 million, they spent 8,965,078 Ghana cedis. Amount is paid from Koto Accountant General. So, what is the case that you have been given 12.9 million and you are telling us you spent 8 million? You have no business holding compensation amount in any special or separate account. If care is not taken, about 3.3 million, this calls for corruption, abuse, and many other related matters. And we are talking about Office of Special Prosecutor. So, the chairman, I raised it with the chairman, and he did agree with me that it was an oversight. So going forward, we need to tidy up this matter so that people will not jump to conclusion that there's some 3 million amount sitting in any account for any other person to do any other thing with it. Let's come to Majority Leader's ministry. you've outlined many projects that you want to undertake in 2024. And it is fantastic, Mr. Speaker, because a lot of things are happening in this chamber, in this house. Many of the people out there don't know what this house is doing. CSOs will just issue a press statement on a subject matter of which many of them have not conducted any serious research into the matter. And by the end of the day, they put the integrity of members and the house at stake. So if the ministry has outlined all these projects going into 2020, especially issues about peace, discussing issues with the Council of State and other stakeholders to promote peace for the upcoming 2024 election, I think it's in order. We need to advocate for more resources for the ministry to do what is right. If you have peace, you have everything. But Mr. Speaker, let's look at the releases for 2023. The approved budget for the ministry was 4.6 million. They got only 2.8 million. So if majority leader, who is in charge of government business, and the Minister for Parliamentary Affairs cannot get his allocated resources, who else? Who else? A cabinet minister in charge of parliamentary affairs, coordinating all the activities of the presidency, and you approve 4.6 million for his ministry. You ended up giving him 2.8. How can he fight for other agencies, other ministers who have no locus, who don't attend cabinet meetings? It's not fair. So 2024, we are expecting the finance minister to do what is right before everybody. Give at least 90 to 99% to the majority leader to undertake all the itemized programs. I've counted and I'm getting almost 15 programs that he's intended to undertake in 2024. So I think he deserves more than how he's being treated. Sumpahene, Unyesika, to wait, he needs more money to do what is right for the country. Thank you very much, Mr. Speaker, for the opportunity.
Yes, let me come to Honorable Deputy Minister for Fisheries.
Thank you, Mr. Speaker, for the opportunity to support the motion. Mr. Speaker, really, the Minister for Parliamentary Affairs and the majority leader of the House, Honorable Nana Sumpahene, really needs a lot of resources. And in fact, I support that argument from a colleague, a champion. Mr. Speaker, the interface responsibility of that ministry, in fact, between Parliament, the Executive, the Judiciary, and even the public as a whole, is very critical. If we really accept that Parliament is the heartbeat of the democracy that we're practicing. As a matter of fact, it is Parliament that has suffered all over these years when coups become successful, and at the end of it all, the executive, the judiciary, and the other arms of government persist and exist. It is Parliament alone that is taken out of the equation, and for that matter, it's a huge challenge. Mr. Speaker, therefore, we expect that this year, the 9.4 million, which is not adequate, at least the release should be forthcoming. I have attended some seminars and some workshops of the Parliamentary Affairs Ministry. Very insightful, very educative, and Mr. Speaker, encourages us to continue to support this parliamentary system as an arm of government. It is therefore very important that we as Parliament, and also looking at our situation and the perception of the public about Parliament today, as if Parliament is not being very important in the equation, there's the need to support such a ministry that is doing all that it can to bring Parliament up to speed and ensure that the public really understand. Therefore, when we are at this stage of the estimate level, I think that the House, we should also try and push more for the majority leader and the minister to have enough to be able to do that. If you look at the 2023, the releases were not forthcoming. As a matter of fact, if you look at the percentage release as at September ending, not too much encouraging, and we are expecting that these few days that is left, Nana Sobahini, maybe the finance minister will make some magic and be able to come up to date on the deficit in terms of the budget allocation, and also to encourage the finance minister to support this Ministry of Parliamentary Affairs to be able to secure and execute its mandate. I thank you for and call for the support of the House for this motion. Thank you, Mr. Speaker.
Lastly, Mr. Speaker, you are my friend, so I thank you. Mr. Speaker, I want to add my voice for the motion on the floor calling for the adoption of this report. Mr. Speaker, in doing so, I want to focus on some matters captured on page 6 of the report. Mr. Speaker, as part of the operational outlook for 2024, the Ministry of Parliamentary Affairs is indicating that they will want to support strengthening the capacity of parliamentarians as well as the leader of government business in promoting transparent elections. Mr. Speaker, inherent in that is the fact that sometime last year, as MPs were assured that offices will be built for us in our various constituencies, and that project will be commenced in phases. So we were encouraged to look for land in our various constituencies, ensure that site plans were properly done in respect of those lands, and some application will be submitted to the office of the majority leader. Some of us have done that. I am worried that as we speak, there's not been any progress, concrete progress in respect of that. Mr. Speaker, it is part of his function to ensure that members get offices. Even if it starts in phases, as he indicated to us last year, we'll be very grateful. Out of the 275, if they start with, say, 70 or even 100, members will be encouraged to cooperate with him to do more as enshrined in Roman numeral 4 of the functions he intends to carry out in 2024. Mr. Speaker, I interrogated the fact that they want to engage security and security-related agencies on their respective roles and responsibilities in promoting law and order. Mr. Speaker, the Minister for Parliamentary Service shouldn't waste his, well, for want of better expression, shouldn't spend his limited resources on the security services in waking them up to their responsibilities, sort of. I think that they are mandated in law to do that. It shouldn't take Ministry of Parliamentary Affairs to live up to expectations, Mr. Speaker. So I raised this matter at the committee level. He hasn't got the resources to do that. Mr. Speaker, again, he indicated supporting the strengthening of the implementation of electoral guidelines, rules, and regulations to reduce monetization in our politics. Mr. Speaker, as we speak, the Minister for Parliamentary Affairs hasn't engaged MPs in our respective constituencies to look into these matters as they pertain in our various constituencies. Then I think that he should do that. He should come to Southdown and hold a community engagement and engage the people and listen to their views on this matter. Mr. Speaker, One other thing I want to draw his attention to is giving effect to the issue of e-parliament. I think that the issue of attendance and non-attendance, punctuality and all, respect of the work that we do in the chamber can be addressed with digitalization. And I think that as the minister responsible for parliamentary affairs, he should champion this for us. A lot of the businesses can be done in cyberspace with effectiveness. So we should consider looking at that. Mr. Speaker, one other matter that I raised at the committee level, which fortuitously has been captured in the report, is the fact that I raised the issue of the constitutionality and legality of the committee that is established to, as it were, look into the review of the Constitution. And the initial impression I had was that they were going to review the review report of the Constitutional Review Commission's work, for which a government white paper had been issued. But he explained the rationale. But I see that as captured in the report, it still gives me cause to worry. Speaker, with your leave, if I may read the portion captured in the report. It says that the intention of the committee is to use the commission of the Constitutional Review Commission's report as the principal document upon which which will lead to a possible review of the Constitution. And in these austere times, how many times do we have to review our Constitution to proceed with the proper enactment leading to the review? So I think that what he should do is for the committee to summarize the CRC's report, lifting the thematic areas where review will be carried through an enactment for his ministry to consider, so that he can submit a bill to that effect. Then the portions, the review of which will lead to a referendum, then he can also prepare the necessary protocols to give effect to that. So they don't have to go back and review the Constitution from Article 1 all the way to Article 299, thereabout. The work has already been done. So it's a matter of sifting the material portions for his consideration. Mr. Speaker, with these words, I want to urge the House to adopt the report. Mr. Speaker, if I may make a couple of corrections, the typographical errors. Mr. Speaker, if we go to page 10 of the report, under paragraph 10(4), line 1, 2, 3, 4, 5, 6, 7, 8, is to the effect that in response, the ministry submitted that the said committee is only mandated to engage the different shades of opinion. So we take out to the different shades of opinion. And also, the last but one line, the ministry explained that, not they explained that, the report of the Constitutional Review Commission will be used as the principal document by the committee. Mr. Speaker, subject to these amendments, I support the motion that the report be adopted. I thank you for the opportunity.
Let him welcome my former Deputy Speaker.
Mr. Speaker, thank you very much for your warm welcome. Mr. Speaker, that's exactly the point. I just rise to make a few comments, and especially about the e-parliament that my colleague and learned friend opposite was so eloquently talking about. Mr. Speaker, the impression these days is constantly being given that if the chamber is like this, it means that perhaps nothing is happening. I'm just from a trade committee meeting. I'm aware that other committee, and it is not for nothing that all these proceedings are broadcast in our offices. And so, Mr. Speaker, if really the matter that is currently being discussed does not fall within your domain, either in terms of parliamentary interest or personal interest, it is not always that you'll be in the chamber. That doesn't mean that you are not concerned about what is going on. And Mr. Speaker, when you go to the Westminster Parliament, for example, apart from Prime Minister's question time and some other maybe serious matters, the chamber is not fully filled. They don't have chairs for everybody. Mr. Speaker, before I came here, I was watching the Home Secretary, they call it in UK, at the dispatch box talking about what they call the Rwanda bill. And Parliament was not full. This is something that I'm going to vote on this evening. It's something that we are told that can even bring the downfall of the Conservative Party. But Parliament was not full. If you go to America, it's the same situation. So I don't know why we seem to be, should I say, criticizing ourselves too much and creating the impression that if we are not in the chamber, we are not working. Today, 11 committees are sitting. And if we have e-parliament and so on, and we don't continuously make the point that parliamentary sitting is not just sitting in the chamber. Parliamentary work is not also just sitting in the chamber. Mr. Speaker, this unfortunate impression will continue going out. I was working on a statement in my office, a statement on something that I want to bring forward next week. You go and you have to give the statement to your leadership and to the Speaker. You can be waiting for a leader in his office. So, Mr. Speaker, as we try and introduce e-commerce, we should also educate people, e-parliament, we should also educate people that Parliament is not like, with respect, a school that you have to start. Even in school now, these days, you don't have to be there. One of my daughters was sitting relaxed somewhere. She's in a medical school, and I wanted to send her. She said she's in the lecture room. I said, lecture room doing what? She said, psychiatry. Where's your lecture? The lecture is in UK, and they are doing it by Zoom. So, Mr. Speaker, we must move. Parliament must move and stop this everyday bashing of ourselves that we are not in the chamber, so we are not working. I know that the people of Ghana have 275 hard-working parliamentarians, and we must continue to encourage ourselves. Mr. Speaker, the tradition is that even when you speak for 1 hour, you say that with these few words. And I'm a man of tradition. So, Mr. Speaker, with these few words, I support the motion. Thank you very much.
Yes, leader.
Thank you, Mr. Speaker. Mr. Speaker, this is a ministry that suffered 8 years absence in our fourth Republican dispensation. And if you look at how the budget of the ministry is being treated now, that is what is compelling me, Mr. Speaker, to be on my feet and make these few comments. Mr. Speaker, we approved a budget of 6.4 million for the Ministry of Parliamentary Affairs. We did not revise the 6.4 million. Mr. Speaker, how can the Minister for Finance revise the 6.4 million to 4.5 and go ahead to release only 2.8 to the Ministry of Parliamentary Affairs? Mr. Speaker, this is a ministry that rescued the Minister for Finance himself when we were going to IMF. He couldn't organize a common platform to engage MPs and explain the post-COVID program to Parliament. Mr. Speaker, it was the Ministry of Parliamentary Affairs that used its country resources to invite members of Parliament to a meeting in Kufuria and to invite the Minister for Finance himself with his team to go and explain the post-COVID program to members of Parliament. Now, after getting your IMF money, you are reducing the ministry that created that platform for you. You are reducing their budget. Mr. Speaker,
this is serious. This ministry, if you look at their core functions, they serve as an interface between the legislature, the executive, and the judiciary. So, Speaker, there is a saying in Akan that one year will be a mawasia, yemon krono. This is a clear punishment. The Speaker, the Sumpahini want me to explain further. And I know, Mr. Speaker, you are urging me to even bring my discussion or my rendition to a conclusion. But, Mr. Speaker, the Minister for Parliamentary Affairs himself understands what I'm saying. I was wondering why their programs of activities in 2023 were not so much until I saw their budget. Mr. Speaker, beyond that, beyond the post-COVID program, Honorable Minister, you remember you took the leadership of Parliament to Kumasi to do engagement on some of those parliamentary programs and those things. How effective that program was. But in 2023, Mr. Speaker, absent. So if you go through the budget, I don't think the Minister for Finance, who couldn't release even 6.4, revised it to 4.5, then release only 2.8. Now he's saying he's going to release 9 million. Is that what we are seeing? If you couldn't release even common 4 million or common 6 million, how can you release 9 million? But Mr. Speaker, we must not take the Ministry of Parliamentary Affairs as if it is a department. Mr. Speaker, it has a serious role to play. And neither, if the ministry is to play its role very well, it can end up creating parliamentary experts so that during certain programs we may not be going to the academia to go and fish for resource persons, because this ministry itself can create resource persons. But when you stifle the ministry out of funds, and you think this 2.8 million in some ministry it's not even enough to buy fuel. Meanwhile, it's the same amount that is used for goods and services, it's the same amount that is used for capital expenditure, it's the same amount that is used for employees' remuneration. Mr. Speaker, this is a serious problem. And I think if you are approving 9 million, that 9 million must be released. And leader, you once chaired GOPAC and APNAC. As part of your activities for 2024, where we are getting to, I think the Ministry for Parliamentary Affairs must factor in APNAC and GOPAC activities in Ghana. You domesticate them. Train us. That is how you were trained and you were able to head APNAC Africa. Without wasting too much time, Mr. Speaker, I know time is not on our side. But there is much to be said. For the budget is really an eyesore. With these few words, Mr. Speaker, once again, I support the motion, but in supporting it, I call on the Minister for Finance to make sure he walk the talk and release this 9 million for our programs in 2024. Thank you, Mr. Speaker, for the opportunity.
Thank you very much. Leader, you conclude.
Thank you, Speaker. Let me show appreciation to colleagues in the House for the comments that they have made. The Speaker, but to explain first that the releases thus far in the region of 2.8 million is because it's captured at the end of September. That's the third quarter. It doesn't include the last quarter. The Speaker, also to explain further that there is a portion that ought to have gone to remunerate a group of people that the ministry has employed. In fact, they are consultants, and it includes many former MPs. They are consultants to the ministry. Unfortunately, some of them have obtained, some of them have gone beyond the year 60. And it becomes difficult for the gift index to have them processed. So their emoluments have remained outstanding since the beginning of this year. I think that is where the problem is. But the Comptroller and Accountant General is working to their emolument is part of the outstanding. And I want to believe that by the close of the year, they should have their salaries provided to them. Not salaries as such, but what is due to them as consultants of the ministry given to them. Mr. Speaker, some fundamental issues have been raised with respect to the review of the budget. It should be appreciated that when you pass the appropriations bill, Mr. Speaker, you're giving the executive a ceiling to expend. If they cannot raise that amount, given the circumstances, and have to bring it down, Parliament will have to be informed that what we came for is being reviewed downwards. To the extent that they do not overshoot the appropriated amount, they have to inform Parliament that it's being revised downwards. That is what it is. Mr. Speaker, if it should go beyond that, and of course you require a supplementary budget to justify that you are going beyond the appropriated amount. That is what it is. And that is what information came to us in the mid-year review. That's the information that came to this House. The Speaker, the constitutional review really, it's intended for a much more holistic review of the Constitution. But what has been done earlier by the Constitution Review Committee, what they came out with, I mean, it cannot be jettisoned. It cannot be jettisoned. It should be a primary-based document. And that is why those of them who even worked on that, Professor Atuba and others, have been incorporated in this committee. And they are working to really enhance what ought to be done. We must all recognize that a lot of water has even passed under the bridge since the conclusion of that report. Mr. Speaker, the other matter that was raised by the Honorable Dafiamoko in respect of offices for members of Parliament, that one really has nothing to do with the ministry. It has to do with the majority leader. The Speaker, it has nothing to do with the Minister for Parliamentary Affairs. It has to do with the majority leader. So he is referring to a different hat altogether. Equally so is the mention of e-Parliament. That is for the majority leader, and indeed the budget of Parliament, not the Ministry of Parliamentary Affairs. That distinction must be made. The Speaker, the monetization, I appreciate the point that you made, that we should endeavor to go to find out the various constituencies, but it's difficult given the budget that we have. Which is why we have engaged the executive, the national executives of all the political parties, and have serious dialogue with them going forward as to what it is that must be done. Speaker, also the engagement with the security services. There are three different ministries directly connected with the security operations of this country. The Ministry of Defense, the Ministry of the Interior, and also the National Security Ministry. But when we talk about national security, it goes beyond these ministries. It will include, for instance, the Ministry of Communication and Cybersecurity. And that is why we've been providing that platform for the meetings to hold. As I speak now, given what is happening up north, because of what we've been doing, the security agencies are knocking on our doors for us to have the meeting again. Unfortunately, given the circumstances of the times, especially considering the budget, it becomes difficult to find space for it. So, in all likelihood, when we finish, perhaps maybe first, second week into next year, it may become important for us to have that meeting again. Already I've told the ranking member on Defense and Interior and other members of that meeting, and certainly we're going to have that meeting again. The Speaker, I think those are the important issues that the members raised, and I want to thank them for the contribution, and also to the Speaker clarify the issue, the figure that's been captured in item numbered 11 as motion. The figure there is 9,432,774. I think it's a typo. It rather should read as obtains in the report. It's 9,423,774. 423,000. The Speaker, the same is captured in the report. I think it's just a mix-up, a typo.
Very well.
Mr. Speaker, thank you.
Thank you. Honourable members, at the conclusion of the debate, the question is all those in favour of the motion listed 11 in today's order paper, say aye. Aye. All those against say no. Honourable members, the ayes have it. The motion listed 11 in today's order paper is hereby adopted, and that this Honourable House approve the sum of 9,423,774 Ghana cedis for the services of the Ministry of Parliamentary Affairs for the year ending 31st December 2024. Yes. Yes.
Speaker, we are taking item 12, motions on page 11. We do the 9? Then you 9. Okay, we are taking item number 9, motion on page 10 by the Attorney General.
I think the motion has already been moved, so the chairman will just second and read the committee's report.
Thank you, Mr. Speaker. You are perfectly right. It was already moved. And let me repeat, I second the motion. And in so doing, Mr. Speaker, I present your report, the committee's report. And I pray that the Hansa Department captures the entirety of the report whilst I read the conclusion of the report. After carefully studying the estimates of the Legal Aid Commission, the committee is satisfied that the programs outlined for the year would go a long way to strengthen the provision of legal aid services to the people of Ghana. The committee recommends to the House to adopt its report and approve a total sum of 33,424,217 Ghana cedis for the services of the Legal Aid Commission for the year ending 31st December 2024. Thank you, Mr. Speaker.
Thank you very much. Ranking, let's be brief so that
Mr. Speaker, I'll be brief. Mr. Speaker, thank you for giving me the opportunity to contribute to the motion numbered item 9 on today's order paper at page 10. Mr. Speaker, legal aid is no longer an agency. It is established as a body corporate by the Legal Aid Commission Act. And Mr. Speaker, in that law, the legal aid, in performing its constitutional function, will have to establish district offices, regional offices. But Mr. Speaker, as we speak, the Legal Aid Commission doesn't even have headquarters. Mr. Speaker, they do not have headquarters. And Mr. Speaker, the total amount being allocated to legal aid is 33,424,217 Ghana cedis. Mr. Speaker, the whole amount of this nature, we should fulfill the legal requirement in Section 100. We establish the institution with responsibilities, but they do not have the resources to be able to perform their mandates. Mr. Speaker, I want us to look at the budgetary allocation and economic classification for 2024. Goods and services is 3,259,500. An institution that is supposed to establish district offices to render legal aid services to the poor and the vulnerable is having allocation for goods and services in the sum of 3 million. Mr. Speaker, an institution supposed to establish district and regional offices that does not even have head office is being given capital expenditure of 3,268,000 Ghana cedis. Mr. Speaker, do we want to have a legal aid as a body corporate, or we still want them to work under the Attorney General and the Ministries of Justice? Mr. Speaker, if you want legal aid as an autonomous body being established by an act of parliament, then with all due respect, as a country, we need to pay some attention to this particular institution. If we don't want the Legal Aid Commission to exist, let us abolish it so that we know we do not have legal aid. To establish it with responsibility to go down to the districts, regional, not only at national, with this kind of budgetary allocation. Mr. Speaker, Legal Aid Commission is not an individual to be given a capex budgetary allocation of 3 million, goods and services to be 3 million. Mr. Speaker, on behalf of the legal aid, I am on my knee that the way and manner additional resources are provided for other institutions, we have to do the same thing to legal aid if we really want legal aid to perform its duties and responsibilities. Mr. Speaker, with this few words, I support the motion for the allocation of this meager amount to the legal aid, praying that they will look elsewhere to be able to give them additional resources to be able to perform their mandate. Thank you once again.
Thank you very much. Honourable members, at the conclusion of the debate. Okay, I'm taking you as the last person. Yes, Honourable Champon.
Mr. Speaker, thank you very much for the opportunity to contribute to the debate on the floor. Mr. Speaker, I just want to make few observations. Mr. Speaker, as a country, we need to come clear on such matters. If we don't need the legal aid, let's scrap it. Because we are pretending as if we have some state institutions whereby anybody who has any issue can run to because of financial issues and the rest. If the state institutions are not well resourced, they can't deliver on their mandates. Your committee report is telling us at item 8, 2023 performance, 8.11, the Commission received 4,580 cases and resolved 1,370, a difference of 2,910. And again, item 2, regarding alternative dispute resolution, the Commission received 7,934 cases and resolved 4,260. A difference of 3,674. Mr. Speaker, what are we doing to ourselves? In other jurisdictions, they call it ombudsman, like a free system where an ordinary person like me, a poor person like me, vulnerable person like me, when you have litigation or somebody is trying to trample upon your right, you run to the office, then the office will step in and provide this legal support for you. Mr. Speaker, go to the offices. They don't have the adequate resources to even attract qualified lawyers to work for them. Together with the Attorney General's office, many seasoned lawyers don't want to work there because their conditions of service are very bad. And we are pretending as if we are state institutions. So if you talk to somebody, oh, go to legal aid. What is there? They can't do anything for you. They don't even have vehicles to traverse across the length and breadth of this country in order to even support our people who are in need. Let's put all the northern zone together. Savannah, Upper East, Northern Region, and the rest. We have a lot of people who have cases because of financial constraints. They can't go to the court for a proper, education. And this system is not there to support these people. And they can also travel to the south to access such facilities. So, Mr. Speaker, let's be frank to ourselves, do what is right. Let's put our money where our mouth is. Giving this money, paying salaries for people who cannot get the mandate, other resources to work, it doesn't make any economic sense to everybody. We are wasting state resources. So this is let's scrap it and say we don't have legal aid. If we want to maintain it, let's resource them so that they can also deliver on their mandate, so that we will not come complaining that they are there, they are not working. NCC, the same thing is happening. Election is coming, you just hear them 1 or 2 on radio campaigning. Are they not state institutions? So, Mr. Speaker, let's allocate resources to state institutions so that they can deliver on their mandate. I thank you very much for the opportunity.
Leader, come. Okay, very well.
Mr. Speaker, I rise to also add my voice to support the approval of the allocated amount to legal aid. Mr. Speaker, I associate myself with the observations made by the committee that we need to up our performance in respect of facilitating the presence of legal aid in the newly created regions. Speaker, we also need to assist them to recruit additional staff and also in the process provide them with office space. Mr. Speaker, we're all lamenting underfunding of various ministries, departments, and agencies. That's a general malaise. But, Mr. Speaker, when one looks critically at the allocated amounts to legal aid, one realizes that indeed some enhancements in the allocation is going on. Mr. Speaker, you look at the amounts allocated to legal aid for goods and services in 2023. Mr. Speaker, for goods and services, the revised budget was 1,445,650 Ghana cedis. Mr. Speaker, for this year, the allocated amount is for goods and services is 3,259,500 Ghana cedis. What this translates to, Mr. Speaker, is more than 100% increase in goods and services. And that should be appreciated. Again, you look at CAPES. For CAPES last year, they were granted only 296,600 Ghana cedis. For this year, Mr. Speaker, the allocated amount is 3,268,000. That's more than 1,000% increase. So even though we may lament that really we are still in the realm of underfunding, certainly this amount allocated is colossal by any stretch of imagination, from less than 296,600 to now 3,268,000. It represents an increase of over 1,000%, and we must show little appreciation for what has been done, even though we may lament overall that it still may not be adequate. And we still agree that it may not be adequate, but what has been done should be appreciated. Mr. Speaker, with that, I conclude by saying that we should be thankful to God for little mercies and move on. I thank you for the space accorded, Mr. Speaker.
Honourable members, at the conclusion of the debate, the question is, as many as are in favour of the motion listed 11 in today's order paper, say aye. All those in favour of the motion, say aye. All those against, say no. Honourable members, the ayes have it. The motion is adopted, and that this Honourable House approves the sum of 33,424,217 Ghana cedis for the services of the Office of the Legal Aids Commission for the year ending 31st December 2024. Yes.
Speaker, we are taking motion 12 on page 11 by leader.
So, honourable members, motion 12, page 11, motion by the majority leader.
I rise to move that this Honourable House approves a sum of 23,542,520 Ghana cedis for the services of the National Media Commission for the year ending 31st December 2024. The Speaker, we do know the functions of the National Media Commission, which includes promoting and ensuring the freedom and independence of the media for mass communication or information, and taking appropriate measures to ensure the establishment and maintenance of the highest journalistic standards in the mass media, including the investigation, mediation, and settlement of complaints made against or by the press or other mass media, and insulating the state-owned media from governmental control, and also making regulations by constitutional instruments for the registration of newspapers and other publications, except that the regulations shall not provide for the exercise of any direction or control over the professional function of a person engaged in the production of newspapers or other means of mass communication. Mr. Speaker, it is for this that the Commission sought and has been allocated an amount of 23,542,520 Ghana cedis for the 2024 financial year. I so move, Mr. Speaker.
Yes, Honourable Member for Asopa.
Thank you, Mr. Speaker. I support the motion on the floor, and in so doing, I present your report. And I also want to urge the Hazard Department to capture the entirety of this report. And in so doing, I present the conclusion of this report. The committee, after careful examination of the 2024 estimates of the National Media Commission, recommends to the House to adopt this report and approve the sum of 23,542,520 Ghana cedis to enable the National Media Commission implement its planned programs for the 2024 financial year. Thank you, Mr. Speaker.
Honourable members, the motion has been moved and it has been seconded. It's before the House. I will take one from each side. Yes, Honourable Leader.
Thank you, Mr. Speaker. Mr. Speaker, I rise to support the motion. Mr. Speaker, the National Media Commission, as you know, is a very important institution that must help oversee and ensure media freedom and independence. Honourable Speaker, if you look at the budget for last year, originally they were allocated about 9 million. In the media budget, they had asked for more money. It was really increased to 12 million. Yet at the end of the year, we only had about 6 million. Up to September, okay? But guess what? So what is really the possibility that this year, the allocation of 23 million they will get? If you look at the challenges they are having, one of the things that I noted in this report is that they don't even have the equipment to monitor the airwaves to make sure they can sanction media houses that, quite frankly, are going foul to their rules and regulations. In the 21st century, in this era of fake news, social media, the National Media Commission is very, very important. And so as we discuss allocation for them, I think it's important we call for an increase in funding as it has been done, but to ensure that it is actually given to them so that they can implement the most important functions as has been outlined in this budget. There's an upsurge in fake news. There's no member of parliament in this house that will tell you that they have not created fake accounts in their name, whether it's Facebook and other media outlets. And it's basically a fight that we cannot win because when you close it down, the next day it's open. I don't know how many times I've gone to the security agencies about fake accounts. And the last time I went to them, I was told that, why are you worried? Even the president and the first lady and everybody else has fake accounts, and it's a struggle. How do we address that? And I think these are very important matters that we have to take a look at. We must also make sure that we sanitize the media landscape. And it can only be done if we strengthen the National Media Commission with the necessary funding. So I hope that this increase in funding to 23 million will actually be given to them so that they can implement the work that they have set for themselves. On that note, I support the motion.
Are you contributing? Okay, you are the last person.
Thank you, Mr. Speaker. I do not have much to say, but I rise to support the motion ably moved by the Minister for Parliamentary Affairs. Mr. Speaker, I'm satisfied with the allocations that have been made. My only problem is with the Ministry of Finance on the releases to the National Media Commission. If only they would release that. So the comment I would is I urge the Ministry of Finance to take this commission very serious and do the releases on time in order that the commission can function the way we expect it to function. Mr. Speaker, with this, I add my voice that the amount that had been earmarked for them be approved for the year ending 2024. Thank you.
Thank you, honourable members. At the conclusion of the debate, the question is as many as are in favour of the motion listed 12 in today's order paper say aye. All those against say no. Honourable members, it's obvious the ayes have it, and the motion is adopted, and that this honourable House approves the sum of 23,542,520 Ghana cedis for the services of the National Media Commission for the year ending 31st December 2024. Yes.
Speaker, we are taking item listed number 13, motion, on the same page 11 by...
Very well. Honourable members, we are on the same page, item listed 13 by the majority leader.
Speaker, I rise to move that this honourable House approves the sum of 23,614,645 Ghana cedis for the services of the Public Services Commission for the year ending 31st December 2024. Mr. Speaker, the core goals and objectives of the PSC is to improve leadership capability and delivery in the public service, and also implement comprehensive human resource management information system for proper ministries, department and agencies planning, and help control data used for the payroll system. The Speaker, they also are purposed to modernize public service institutions for efficiency, effectiveness, to ensure optimum productivity. The Speaker, it is for this that the Commission has sought for and is being allocated an amount of 23,614,645 Ghana cedis for the discharge of their responsibilities. And accordingly, Mr. Speaker, I submit and so move that the House approves of the sum for them. Submit.
Thank you very much. Yes, honourable member for Asoko.
Thank you, Mr. Speaker. I support the motion ably moved by the majority leader and leader of parliamentary affairs. And in so doing, I'd like to pray on the Hazard Department to capture the entirety of the report. And I'll proceed to read the conclusion and present your report. And I proceed to read the conclusion of that report. Mr. Speaker, the committee has carefully examined the 2024 annual estimates of the Public Service Commission, and having regards to the strategic role of the Commission in improving public service delivery, recommends to the House to adopt its report and approve the sum of 23,614,645 Ghana cedis to enable the public sector implement its planned programs and activities for the 2024 financial year. Thank you, Mr. Speaker.
Thank you, honourable member. Yes, honourable member for
Speaker, thank you. Public Service Commission's mandate to ensure a very efficient workforce and to ensure that the human resource capacity of the public services is really well managed. Honourable Speaker, if we look around the public services and all the challenges we see, whether it is productivity, It's a reflection on how effective the Public Service Commission is. It is very clear to me, as it's been outlined in this report, they have a lot of challenges, including how they can build capacity to manage the public services. In 2023, 28 million was what was allocated. The actual money that was given to them was about 9,427,000. In 2024, the allocation is 23 million. What is the guarantee that they are going to get an increase more than 2023 to be able to address the issues that I have just stated? If indeed we want a very effective public service, to make sure the human resource capacity is well managed with modern programs that ensure pay for performance, people making sure that they actually work for the pay they get, that they don't come and just sleep on the job. We have to strengthen the public services. And on that note, I support the motion. Thank you.
Yes. Honorable Deputy.
Thank you, Mr. Speaker. Mr. Speaker, to also support the motion and urge members to do same. Mr. Speaker, the challenge here is that in terms of the human resource numbers, you can even track it from the compensation. If you compare the compensation for 2023 and 2024, you realize there's no much significant difference in there, indicating that we will still have challenge in terms of the human resource numbers. And I think that the Public Service Commission is key, especially if you look at the services that boards are supposed to render in government institutions, with all the boards established by acts establishing those institutions. The board is supposed to lead in terms of policy directives, and the commission is supposed to at least bring them up to speed and bring the boards up to the level that we needed, and also to provide quality outcomes and quality services. So the human resource is key. We also try to urge that the finance ministry should for 2024 be timeous in their releases to ensure that the Public Service Commission really work. Mr. Speaker, in reality, the main functioning of governance in terms of implementation is in there, both the public service and the civil service. And if we really want government machinery to move and provide the quality service that we need, apart from the state that they do, that is where we need to push a lot, because there's a function of public service. There's a function of providing service. And if you compare provision of service at the public sector to the private sector, Mr. Speaker, you see a huge difference. Because the private sector going with quality, speed, and rate. At the same time, the human resource and compensation are really adequate. So I believe that 2024, if we really want to achieve more, this post-COVID time, that we need more public service quality work. I think the budget for them and the releases must be timeless. And when we do that, we should be able to endanger a lot of good work from them. I thank you and wish that we all continue to support the public service and the work that they've done so far. I love my heart for them, for the good job that they've done. But there's more room for improvement. Continuous improvement should be their culture, so that at the end of the day, we will achieve a lot for Mother Ghana. I thank you for the opportunity.
Yes.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, ordinarily once my deputy leader has spoken, I wouldn't speak. But I was part of the Special Budget Committee that met the Public Services Commission. Mr. Speaker, they raised serious concerns before the committee, which the report has captured, and which I think I must re-emphasize
for us as a country to be able to address them. Mr. Speaker, the staff strength of the Public Service Commission for the entire country is only 100. They applied for financial clearance to recruit 23 members to be added to the 100 to make it 123, which according to them, some of their members are about to retire. And even they don't have the staff strength to be able to carry on the good job that they are supposed to do. But looking at their core functions, Mr. Speaker, they are responsible for the management of the human resource capacity of our country. Mr. Speaker, just yesterday or day before yesterday in this house, if you go through the Public Accounts Committee report, payroll irregularities, unearned salaries, and so many things find their space in our public institutions. Mr. Speaker, the Public Services Commission, the number of people on the government wage bill that they manage has been doubled or tripled. If I listen to the Vice President yesterday or day before yesterday, he said they've recruited about 2.1 million people in both public and private. 900,000 are in private. 1.2 million people have been recruited into the public sector. And these 100 people in the Public Services Commission is responsible for managing such a human resource. Mr. Speaker, if you have recruited about 1.2 million people into the public sector, why is it that you are depriving or denying the Public Service Commission of only 23 members? Mr. Speaker, if you want to organize an interview in this parliament, the Public Service Commission has to be represented. Anywhere that you want to do promotional interviews and all these recruitment interviews, they have to be present. And they are only 100. Mr. Speaker, patients of the Public Service Commission must be taken very serious. And we as a committee, that's why we put it in our report, that we want to make a very strong case for them. So at least the 23 people that they want to recruit, Mr. Speaker, must be given to them. When it comes to other institutions, you see, the Public Service Commission is a constitutional creature. The report that appeared before us, Audit Service, for instance, recruited about 200, recruited about 150. Special Prosecutor recruited about 200. Local Government Service recruited about 10,000. And Public Service Commission is only asking for 23, and you are denying them. Mr. Speaker, you are adding to the inefficiency in the human resource management in our government institutions. And if the government institutions are not strengthened, if the human resource capacity of the government institutions is not strengthened, Mr. Speaker, we may be giving them money for work, but we may not be getting the result that we need. So I want to suggest that, Mr. Speaker, the leader of government business must take this matter to the Minister for Finance very serious. At least they need only 23. And that 23, Mr. Speaker, even though we are in IMF or we are on IMF program, but you see other reports, how other departments and institutions have recruited. So please and please, leader, this one, we have to make a strong case for the Public Services Commission, for them to be able to do their constitutional mandate that has been given to them. With these few words, Mr. Speaker, I thank you for the opportunity.
At the conclusion of the debate, the question.
Mr. Speaker, my colleague has raised a matter which I guess I must provide further elucidation on. You see, the Public Services Commission. Mr. Speaker, the Commission has many more employees than what maybe is being accounted for. And the reason is simple. The Constitution provides in Article 194, there shall be a Public Service Commission which shall perform such functions as assigned to it by the Constitution or by any other law. The Public Service Commission shall consist of a chairman. a vice chairman, and 3 other members who shall be full-time members of the commission. There are others who are non-full-time members. That should register on my colleagues. So when you're talking about that number that's given, those who are remunerated, but there are so many others who are not full-time members of the commission. That should explain to my colleague. I thank you.
So, honorable members, the question is, as many as are in favor of the motion listed 13 in today's order paper, say aye. All those against say no. Honorable members, the ayes have it. The motion listed 13 is hereby adopted, and that this honorable house approves the sum of 23,614,645 Ghana cedis for the services of the Public Services Commission for the year ending 31st December 2024. Yes.
Speaker, we are taking item listed number 14, motion on the same page, 11 by Leader of the House. Thank you.
Yes, Honorable Majority Leader.
Mr. Speaker, before moving the motion, let me effect a correction in the motion as advertised. The figure there should read 88,200,000. Okay, it's 277. Mr. Speaker, I believe this.
Is correct.
Mr. Speaker, a moment. That's Speaker, I'm sorry. What is captured in the report is correct. In the order paper is correct. What is in the report is incorrect. It is 88,277 Ghana cedis, 405. What is there is 88,227,000. So let's correct that. The other should read 88,277, not 27. So, Mr. Speaker, I rise to move that this honorable house approves the sum of 88,277,405 Ghana cedis for the services of the Commission on Human Rights and Administrative Justice, SHRAG, for the year ending 31st December 2024. Mr. Speaker, we do know the mandate of the Commission, that their charge includes the investigation of complaints of violations of fundamental human rights and freedoms, injustice, corruption, abuse of power, and unfair treatment of any person by a public officer in the exercise of his or her official duties, investigating complaints concerning the functioning of the public services, the administrative services, the offices of the Regional Coordinating Council and the District Assembly, the Armed Forces, the Police Service, the Prison Service, insofar as the complaints relate to the administrative organs of state in respect to the failure to achieve a balanced structuring or equal access by all citizens. Speaker, also to investigate complaints concerning practices and actions by persons, private enterprises, and other institutions where the complaints allege violations of fundamental rights and freedoms under the Constitution. Investigating all instances of alleged or suspected corruption, misappropriation of public funds by officers, and to take appropriate steps, including reports to the Attorney General and the Auditor General resulting from such investigations. Mr. Speaker, I dare say that that list would include the Office of the Special Prosecutor. Investigating complaints of human rights violations by persons and institutions in both private and public sectors, and investigating complaints and allegations of corruption and misappropriation of public resources. Mr. Speaker, it is for the discharge of these functions that the Commission sought and has been granted an amount of 88,277,405 Ghana cedis. And it's in respect of this allocation that I move that this House approves. Same for the discharge of the functions of the Commission on Human Rights and Administrative Justice for the year ending December 31st, 2024. Mr. Speaker, I so move.
Thank you very much. Yes. Honorable Madam Patricia.
Thank you, Mr. Speaker. And I rise to support the motion ably moved by the Majority Leader. In doing so, Mr. Speaker, I want to present your committee's report, and I pray on the Hansels Department to take the entirety of this report. So I move straight to the conclusion of the report. And the committee, having carefully examined the 2024 annual estimates of the Commission on Human Rights and Administrative Justice, SHRAG, recommends to the House to adopt its report and approve the sum of 88,277,405 Ghana cedis for the implementation of the programs of the Commission for the 2024 financial year commencing 1st January and ending 31st December 2024. Thank you, Mr. Speaker.
Thank you very much. Honourable members, the motion has been moved and it has been seconded. It is for the consideration of the House. Yes, Honourable Deputy Minority.
Thank you, Right Honourable Speaker. I rise to support the motion. In doing so, I note how important SHRAG is. I note the challenges that this very important institution is facing. One of them has to do with the establishment of SHRAG offices in all the regions and districts. And in reading the report, it has always been that SHRAG is inadequately resourced to open offices. And so the call is for the Ministry of Local Government working with MMDAs to try to make sure they can accommodate SHRAG in the various district offices. I don't know, Speaker, if you are in a district like Elembele district, and you have a challenge that requires the services of SHRAG, what it means is that you have to come to Accra, as I recently did, to basically file a petition on behalf of a constituent. But that is not what the Constitution has envisioned. Justice and rights of citizens must be at their doorsteps, and that requires that SHRAG offices must be close to the people. And that is why it's very critical that these offices are really open in the various districts. I call on the Ministry of Local Government to work with the SHRAG office to make sure we can implement that. And that can easily be done if that effort is made. There's also a note that SHRAG basically has challenges acquiring movable assets. There's also some delays in a lot of the projects that they want to do. All of them boils down to inadequate funding. Last year, about 88 million was what was allocated. They only had about 57 million. This year, we are told that a total of about 88,270,000 is what has been allocated. I'm just hoping that the ministry will make sure that they get enough allocation, at least 100% of this allocation, so that SHRAG can indeed be independent and perform this very important function that has been called for by this Constitution. I thank you, the Honourable Speaker, and I support the motion.
Yes,
thank you, Mr. Speaker, for the opportunity to support the motion. And Mr. Speaker, I think SHRAG is really turning out the desirable outcomes, and they need to be encouraged and motivated. Mr. Speaker, you see that their budget still stands around the same compared to last year, but we believe that this time around they will still continue to do their best. There's one thing that SHRAG is charging in the lead, Mr. Speaker, it is identifying corruption risk and mitigating the plan and the pathway to take. In fact, they've done a good job with fisheries, where we could identify the risk of corruption. And you know, at the high seas, because of IUU activities and other issues on the high seas, they are able to assess the corruption risk, and then a good cogent plan is put to it as to how to mitigate it. And it is running through all the sectors in the ministries. And I believe that this key area will help this country in fighting corruption. It's a UN-sponsored program, and World Bank is also attached to it. And I think that when we support them with the budget, they should be able to run through all the ministries as they've done with this. And it has really opened our eyes to a lot of areas. We've identified the risk, the possible areas of corruption, whereas they are using the illegal, unreported and unregulated fishing activity, and whatever happened at the high seas is really opening our eyes. I believe that we should continue to support them and hope that the 88.2 million Ghana cedis as estimate for them could be used for some of these activities, including the rest of the work plan and activity plan and program plans that they have. I thank you for the opportunity.
Yes. Honorable Deputy Minority Whip.
Thank you, Mr. Speaker. Mr. Speaker, I rise to add my voice to the motion on the floor and to urge members to approve it. Mr. Speaker, SHRAG serves as the secretariat for almost all the anti-corruption agencies. By looking at the budgets we are approving. We just approved 149 million for the last bill, that special prosecutor. And we are approving 88,277 million for the SHRAG, the mother secretariat itself. Mr. Speaker, why will we keep on creating anti-corruption institutions? Because we create it today and tomorrow we fail to resource it adequately. They intend to blame it as if it is not being effective. Mr. Speaker, clearly in this country that we are, the most respected agency, as you and I know now, is the SHRAG and the special prosecutor, but they work together. So, Mr. Speaker, the 88,277,000 cedis, Mr. Speaker, is not enough. We asked them, why are you giving this? He said they were engaged by the Minister of Finance and said because of the challenges of the time. But, Mr. Speaker, if we don't resource SHRAG and resource SHRAG very well, very soon, the little image that SHRAG has as an anti-corruption agency, that when people are trained, I will take you to SHRAG, even ministers wobble, officials, you see them wobbling, simply because SHRAG will deal with you objectively. Yeah. So, Mr. Speaker, if you have such a glorious constitutional body that is able to earn itself the kind of respect that SHRAG has, I think we must not think that SHRAG is okay. If you complete university with a mate and they put SHRAG and special prosecutor, where will you go? Even now, some will prefer to go to special prosecutor, which is just recently created. But if, when SHRAG was created in 1992, Mr. Speaker, if we kept on resourcing it, making sure that they were giving whatever they needed, the way we have reached now with this our correction fight, Mr. Speaker, would have gone further. And there wouldn't have been the need at all to create either special prosecutor or other anti-corruption agencies, because we will have equipped and resourced the independent constitutional body, which is the ombudsman, the work that they were supposed to do. Failure to do that, that's why we are incurring huge capital expenditure and infrastructure expenditure in establishing new ones. Special prosecutor recruited 200 people. SHRAG said they recruited only 40 people. Even they are present not in all the districts. Mr. Speaker, are we serious in our correction fight? You established a constitutional body in 1992, and you said you were going to must have it present in almost all the districts. As I speak to you, Mr. Speaker, we have 261 district assemblies in this country, but SHRAG is only present in about 180. Mr. Speaker, where did we go wrong? If we want to fight corruption, Mr. Speaker, we must treat SHRAG fairly. With these few words, Mr. Speaker, I thank you for the opportunity.
Honourable members, at the conclusion of the debate, the question is all those in favour of the motion listed 14 in today's order paper, say aye. All those in favour say aye. All those against say no. Honourable members, the ayes have it. The motion is adopted, and that this Honourable House approve the sum of 88,277,405 Ghana cedis for the services of the Commission on Human Rights and Administrative Justice for the year ending 31st December 2024. Yeah. Are you taking 15?
No, we are taking presentation of papers, page 8. Page 8 by... Page 8. V3 by leader. Thank you. V3.
V Victoria.
V on page 8. I.
Very well. We are taking only the I. Okay. By the chairman of the committee.
Report of the Special Budget Committee on the annual budget estimates of the Audit Service for the year ending 31st December 2024.
Honourable members, the report has been duly presented. They are for the distribution to honourable members.
Speaker, we are taking item listed number 15 on page 12 by leader. Thank you.
Yes, Honourable Majority Leader.
Mr. Speaker, item 15, not motion 15. Mr. Speaker, I rise to move that this Honourable House approves the sum of 100,547,192 Ghana cedis for the services of the National Commission for Civic Education for the year ending 31st December 2024. Mr. Speaker, the National Commission for Civic Education exists to perform the following functions: create and sustain within society the awareness of the principles and objectives of the Constitution as the fundamental law of the people of Ghana, educate and sensitize, and also encourage the public to defend the Constitution at all times against all forms of abuse and violation. Formulate for the consideration of government from time to time programs at national, regional, and district levels aimed at realizing the objectives of the Constitution. Formulate, implement, and oversee programs intended to inculcate in the citizens of Ghana awareness of their civic responsibilities and an appreciation of their rights and obligations as a free people. The Speaker, to assess for the information of government the limitations to the achievement of true democracy arising from the existing inequalities between different strata of the population, and make recommendations for redressing these inequalities. The Speaker, it is for the discharge of these responsibilities, that the NCC has been allocated an amount of 167,547,192 Ghana cedis for the performance of these functions in the 2024 financial year. Accordingly, the Speaker, I submit that the House approves of same to the Commission for the performance of their functions. As we submit, Mr. Speaker.
Yes, Honourable Patricia PJ.
Right, thank you, Mr. Speaker. I rise to support the motion ably presented by the Majority Leader of Parliament. And in doing so, I present your committee's report. And Mr. Speaker, I want to pray that the Hazards Department adopts the report in its entirety, and I'll proceed to present the conclusion for this report. And Mr. Speaker, The committee has thoroughly examined the planned programs of the E in relation to the critical role of the NCC of promoting civic education, raising awareness on principles and objectives of the Constitution, and promoting citizenship education in Ghana, especially in the upcoming general elections, and therefore recommend to the House to adopt its report and approve the sum of 167,547,192 Ghana cedis for the implementation of the programs and activities of the National Commission for Civic Education for the financial year ending 31st December 2024. Thank you, Mr. Speaker.
Thank you, honourable members. The motion has been moved and has been seconded. It is for our consideration in this House. So, honourable member for Lembele.
Thank you, Mr. Speaker. Mr. Speaker, the National Commission for Civic Education, NCCE, is a very important institution. If you look at the outlook and what they intend to do this year, it is as if that is really very critical. They intend to do tax education, election-related civic engagement with in-school youth, sensitization on anti-corruption and national anti-corruption action plan, engagement on sustainable management of the environment. All of these are very critical. Sometimes you ask, who is responsible for educating the people of Ghana on how to protect our environment, on how to make sure we are responsible citizens, on how to make sure there's peaceful coexistence? It is the NCCE. Yet, Honourable Speaker, this is an institution that has not gotten an office since its establishment in 1992. They still are perching at the old office of the Electoral Commission, because on an annual basis, the allocations we give them in the budget, they don't get it, or in full. This year is not even different. How do we, the NCCE, to make sure they can play that very important role? Just last week, we were talking about the district assembly election and its low patronage, and how we can get Ghanaians to understand that our democracy's anchor is at the district level. It can only be done by the NCCE. And the NCCE can only function if they have adequate resources. And that is why it is important that we resource this very important institution to play their constitutional role, so that our democracy will have meaning. It is on this note that I called on the House to support the motion for the approval of the amount allocated to the NCCE. Thank you, Honourable Speaker.
Yes, I'm moving the same pattern from Majority Leader to Asokwa. Then I come here, go here, come here. So, Honourable Member for Trouble.
Speaker, for the opportunity to support the motion and urge colleagues to do same. Mr. Speaker, it's very exciting to see how the budget for NCC has been increased for 2024 in relation to 2023. 2023, some 72.6 million Ghana cedis. 2024, 167.5 million Ghana cedis. For me, it's very exciting, and we believe that the releases will go through. But, Mr. Speaker, two key achievements in 2023 for the NCCE. And, Mr. Speaker, it is this: the nationwide tax education campaigns in support of the government's revenue generation drive. A very good one that they did, which of course we all knew that looking at our tax component in relation to our GDP, we seems to be very low, the lowest in the West Coast, even in the West Coast here. And therefore, that education is very key. Then, Mr. Speaker, the other one, the NCCE collaborated with the Church of Pentecost, my church, during the inaugural 2-day National Development Conference on the theme Moral Vision and National Development, which aimed to gather suggestions to shape the creation of a national moral value framework. Mr. Speaker, our moral fiber in this country really have to work on it. And with the working on it, we need such sensitization, such education, even from the public perspective, from the school perspective, from the SHS perspective, and from the tertiary perspective. We need to look at our moral fiber. We need to work on it so that citizens will be good citizens for this country. Mr. Speaker, NCCE is critical coming 2024, which is an election year, and therefore their budget that will be increased. I know definitely a lot of education on election has to be done. But one important area that I think NCC can look at, Mr. Speaker, is hate speech. Mr. Speaker, hate speech is becoming a problem in this country. We really have to talk it out and let people desist from hate speech. After all, what is democracy? It's an accommodation of each other. Give and take. Meet each other at the middle. Speak your mind, I speak my mind at the end of the day with responsibility. The fact that there's freedom of speech doesn't mean it goes without responsibility. Therefore, on the airwaves, if you are making hate speech, Mr. Speaker, we need to educate our people so our people will stop hate. We know what hate speech has brought to other countries, and I'm beginning to see it coming up. NCCE have to work on it and make sure that the responsibility of citizens as to this democracy, the sustainability of this democracy is not in the provision of the amenities that we all want for our people. Yes, but it is also that the citizens themselves also have some responsibility to provide to the sustainability of the Fourth Republic and the democracy that we are practicing. So, Mr. Speaker, NCC is a very important commission, and we need to support them. And seeing this astronomical increase of their budget, we want the releases to come. More so be an election year, so they can do their best in education, their best and civil responsibility to make sure we work together and get the outcome. I thank you for the opportunity, Mr. Speaker.
Yes, Honorable Ahmed.
Thank you, Mr. Speaker, for the opportunity. I rise to support the motion on the floor. But, Mr. Speaker, I will not belabor the point in repeating what has already been said. But one critical challenge faced by the NCC is lack of office accommodation. Mr. Speaker, I just spoke about SHRAG and spoke about special prosecutor, the newly created ones. NCC was created, a constitutional body created in 1992. But, Mr. Speaker, till we speak, like my deputy minority leader said, they are still patching. They were patching with the electoral commission, sharing a common bed accommodation. We built for the electoral commission. Instead of the electoral commission to shift and leave the old building for the NCC, the electoral commission wants to use both buildings. Mr. Speaker, how will you term this, and what adjective will you use to classify such attitude? Should we use hard-earned taxpayers' money in building another accommodation for the NCC? The answer is a big no. Electoral Commission cannot use the two buildings concurrently, because we use the hard-earned taxpayers' money to build for both of them to accommodate. If you are saying the space you were occupying there while you were sharing the same accommodation with the NCC was not enough, therefore we've used the same taxpayers' money to build a brand new accommodation for you as a electoral commission. You've moved there. You've locked the old one. You want to use both. And Mr. Speaker, when you talk, they say, oh, I'm independent constitutional body. Mr. Speaker, no matter how independent you are, somebody appointed you. In this, Mr. Speaker, the Special Budget Committee must have a say, and the Chief of Staff and the Office of the President must also have the say. Mr. Speaker, the Electoral Commission cannot occupy the two houses. It never happens. And we cannot be saying that we are going to build a new office for the NCC. Mr. Speaker, people are attending schools under trade. People are attending cheap compound or hospitals or clinic under trees. So this is not the time to say that we are going to budget another money to go and build for National Commission on Civic Education. This house must search in calling the two beautiful ladies and tell them, if both of you were sharing the old one, now we have built a brand new for you, move in. NCC, take the old one. This is the simple solution we must do. Mr. Speaker, look at their budget. NCC is what it is because we think their services are not as essential services like the EC. Mr. Speaker, that is not the case. We went to Rwanda. Mr. Speaker, me and the clerk at table. Mr. Speaker, in Rwanda, what they told us is that you people hear the good news about Rwanda, but the first thing you must do is mental shift, attitudinal change. If there's going to be a mental shift for us to be able to have the huge infrastructure and the huge development that we are yearning for, there must be a mental shift. And that can only be done by the NCC. Mr. Speaker, even the time has come that when we are approving the Electoral Commission budget, voter education and all those things must be done by the NCC. Because the two work together. But gradually you've taken all the functions and you think that even accommodation you want to take it to. Mr. Speaker, that cannot happen. The NCC also explained that they are going to do moral education and sensitization together with the Church of Pentecost Moral Development Conference that we did. Mr. Speaker, for your information, the National Moral Development Conference that was organized by the Church of Pentecost was sponsored wholly by the church. So if the NCC has seen the need that they want to partner the church, they must come and we must support them so that we take it as a national project. We will be able to kill the moral canker. We will be able to succeed in doing the mental shift. We will be able to succeed in building in Ghanaians the Ghanaian values and principles so that we can shift the development to the path that we want and the direction that we want to go. With this few words, Mr. Speaker, I thank you for the opportunity. And may we approve and urge the House to approve this budget for the NCC for the year 2024. Thank you for the opportunity, Mr. Speaker.
Yes, Leader.
Mr. Speaker, I should thank colleagues for eloquently supporting the motion to approve the allocation set out on the other paper for the NCCE. Mr. Speaker, we all do recognize that the NCCE indeed has become the poor cousin of the Electoral Commission, and that certainly cannot be good for us. Mr. Speaker, I do recollect that about 12 years or so ago, the Electoral Commission, in their annual budget, came to be allocated a huge amount for education on HIV/AIDS. HIV/AIDS. which was supposed to be the responsibility. And yet, this very house gave the amount to Electoral Commission instead of the NCC. I raised issues with it. I was, where is the here? You say, were you here or here? Which of the years that are you referring to? Yes, at the time I was on the left-hand side of God the Father. The Speaker will raise this. Today, we are informed of where the Electoral Commission, the NCC is. They used to share the head office of the Electoral Commission with them, and they were really at the periphery of that office. The Speaker, today a new structure has been built for the Electoral Commission. Truth be told, we should strongly urge the Electoral Commission to hand over that facility to NCCE. I do know that the Chief of Staff has been invited to intervene in this, but it looks like there is a lot of prevarication on the part of the Electoral Commission. As a house, we should stand together and urge them to hand over the facility to NCC. The Speaker, once we come together, we will not have any option than to do that. I don't think it's right. So the Electoral Commission should be advised to help themselves and also help the other constitutional creature to have that office. Mr. Speaker, the duties of a citizen are set out in Article 41 of the Constitution, and it is for the NCC to educate citizens on this. Mr. Speaker, every citizen is required to promote the prestige and good name of Ghana and respect the symbols of the nation. We are to uphold and defend this Constitution and the law. C says to foster national unity and live in harmony with others. We're talking about hate speech. Mr. Speaker, it appears some of our people, social commentators, journalists, did not consider this. The imperatives of Article 41 of the Constitution. You are to respect the rights, freedoms, and legitimate interests of others, and generally refrain from doing acts detrimental to the welfare of other persons. Today, it's like any person who thinks that he has two microphones in front of him can do whatever he or she pleases. And it's certainly not good for the stability and unity of this country. Speaker, the NCCE should be empowered to sensitize Ghanaians on their responsibilities as responsible citizens of this country. Mr. Speaker, the person is required to work conscientiously in his lawfully chosen occupation. The Constitution should serve as a guide. So, Mr. Speaker, I think that the NCC has very onerous responsibilities, and we should capacitate them to perform their functions. That's why I'm happy that members are responding to this positively. And I should express my profound gratitude to members who have contributed to this motion thus far. Mr. Speaker, thank you.
So, honourable members, at the conclusion of the debate, the question is as many as are in favour of the motion listed 15 in today's order paper. Say aye. All those against say no. Honourable members, the ayes have it. The motion listed 15 in today's order paper is hereby adopted, and that this House approves the sum of 167,547,192 Ghana cedis for the services of the National Commission for Civic Education for the year ending 31st December 2020. 2024. Yes, Lina.
Speaker, we are taking the item listed on order paper addendum 2 motion by our leader of the House. Once again, Swampa him.
Leader, have you already distributed the reports?
Mr. Speaker,
The reports are already distributed.
the reports have already been.
Yes, leader, let's hear you. You just entered in. So,
Mr. Speaker, I beg to move that this Honorable House approves the sum of 633,740,507 Ghana cedis for the services of the Audit Service for the year ending December 31, 2024. Mr. Speaker, as one of the tools, indeed in the hands of Parliament, in the performance of our oversight and our accountability functions, the core functions of the Ghana Audit Service are to ensure that the auditing activities of the Ghana Audit Service, as spelled out in the Audit Service Act, are carried out in accordance with best international practices. Mr. Speaker, the Audit Service is to also audit and report to Parliament the public accounts of the Republic and indeed of all public offices, including the courts, the central and local government administrations of the universities and public institutions of like nature, and of any public corporation or other body or organization established by an act of Parliament. Mr. Speaker, the Audit Service also ensures the effective and efficient implementation of the Assets and Liabilities Declaration regime. Mr. Speaker, it is for this purpose that the amount of 633,740,507 Ghana cedis has been allocated to the Ghana Audit Service. And accordingly, Speaker, I reiterate my call for members to approve of the motion to have this amount approved and allocated to the Audit Service. The Speaker, I should submit.
Yes, Honorable Patricia.
Thank you, Mr. Speaker. I rise to support the motion on the floor ably presented by the Majority Leader. I wish to present your committee's report. And in doing so, Mr. Speaker, I'd like to pray the Hansard Department to capture the report in its entirety. And I proceed to state the conclusion by the committee. Mr. Speaker, to empower the Audit Service to play its constitutionally mandated role, the committee recommends to the House to adopt its report and approve the sum of 633,740,507 Ghana cedis for the implementation of the programs of the Audit Service for the 2024 financial year. Thank you, Mr. Speaker.
Thank you very much. Yes, Honorable Member for Bill.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise to support the motion ably moved and seconded by colleague that this Honourable House approves the allocation for the audit service for 2024 financial year. And in doing so, Mr. Speaker, one issue that was of worry to us was the fact that there was delay in release of their budgetary allocation, which affected the auditing of the foreign missions. And so they expected to have done auditing of about 42 of these missions, but they couldn't. In the 91.75% institutions that they dealt with, none included the foreign missions, and where we end up spending quite a lot of our money. So it is the expectation of the House that the Ministry of Finance will release the funds approved to the audit service to enable them do all the necessary auditing areas. And this, Mr. Speaker, has been ably captured in paragraph 7.1, page 10 of the report. We say the committee was informed that the service could not audit missions abroad due to non-release of the goods and services component of the budget. And we don't expect that you allocate monies to the audit service and you don't release it to enable them perform the functions that is due them. In terms of their reports, Mr. Speaker, I think their reports have been timely sometimes, and the Public Accounts Committee, together with them, have worked on the reports, and this will go a long way to save us our money. I know time is not available, so I support the motion that the allocation to the audit service is approved by the House. Thank you.
Thank you very, very much. Yes, Honourable Member for Trouble.
Thank you very much for the opportunity, Mr. Speaker. Let me support the motion and also urge colleagues to do same. But because Majority Leader is here and Minister for Parliamentary Affairs, just to ask whether the Auditor General is a tool for Parliament or is a tool for the Executive. It's a tool for Parliament, that's right. And I think this issue must come out clear. And whilst we're passing their budget, this issue must come to the center so that nationally everybody will know that the Auditor General is a tool for Parliament or a tool for the Executive. Mr. Speaker, also to draw attention about the 2024 staff recruitment that they want to do. The committee has recommended 50% of it to be done as a recommendation. They are asking for 200, and the committee, looking at 2024 and looking at our budget and how constrained we are, and we're supposed to leave a bit lean. Therefore, they are recommending that they should rather go 50% of the staff recruitment, meaning if we should approve this report, that is what will stand. It will mean that they are to recruit 100, not 200. And I just want to draw their attention. I also want to draw their attention that yes, the Auditor General some time ago lagged a lot when it comes to their report. It looks like they are coming up to date. Let's encourage them and then support with all the necessary budgetary that we needed to do so they can come. They are very important too for Parliament, and the audits that they do, check and balance, ensure that the right things are done. We've done budget. Parliament select committees will definitely oversee the executive performance, but at the same time, the Auditor General brings us to speed as to the issues that have been done. But the Auditor General's work always is a post-mortem. What is important is the other organs that we are supporting, which our prevention is better than cure type, which we need to encourage and integrate all these organs and make sure work done. I support the approval of the amount given to them, and we are expecting a continuous improvement in the work of the audit service. Thank you for the opportunity.
Thank you very much. Yes, lastly,
Thank you, Madam Speaker. Let me commend the Audit Service. The report notes that the Audit Service did very well. For instance, out of the targeted 6,723 planned audits, 6,166, representing 91.72, was actually completed at the end of September 2023. And this was submitted by the 15th Auditor General's report deadline to Parliament. And so we must commend the auditor, especially if you look at the fact that the allocations that were made, there was a shortfall. 608 was what they were supposed to get. They got 446, representing 73%. If you look at the responsibility of the Audit Service, it means that it is important that the allocations that is made to them, they actually get. We are hoping that in 2024, the amount that has been allocated, which is 633,740,507 million, will be allocated to them. What was very concerned to me was the comment that was made in the report of the challenges they are having with the construction of office buildings in some of the regions. That really hampers their work. It is also very clear that the responsibility of the Audit Service is too huge across the country. All secondary schools, every institutions of government across, and yet we are here talking about they are asking for 200 people to increase the staff strength to deliver on their work, and we are saying that we should cut it by half. We should give them what they need to do their work. It's as simple as that. And so, on that note, I ask us to support the allocation to the Audit Service. Thank you, Mr. Speaker.
Yes, lastly.
Mr. Speaker, let me make few comments on the submission. Mr. Speaker, I was part of the committee that recommends that the number that the Auditor General wants to recruit, the 100 be scaled down to 200 be scaled down to 100. Mr. Speaker, the Auditor General has a numerical staff capacity of 2,229 nationwide. Mr. Speaker, last 2 years ago they recruited 200. Last year they recruited 150, making 350. They want to recruit next year 200, making 550. And given the challenges where we find ourselves, they are saying that the 200 is scaled down to 100, so that at least the number of people recruited within these 3 years will come to 450. That aside, Mr. Speaker, the Auditor General, if you want to fight corruption, the Auditor General is one of such important institutions that we must make sure that we strengthen. Mr. Speaker, until recently, that we increase the number of staff. That is why they are able to deliver timeous report for the Audit Public Accounts Committee to go and scrutinize. There used to be 2-3 years backlog of reports to be audited. By the time they audit, some staff have even gone on retirement, some have passed away. So the fundings were difficult to be implemented. But now, I think they are about 1 or 2 years late. That aside, the most critical challenge facing the Auditor General, Mr. Speaker, is office accommodation. We have 261 MMDAs, district assemblies. Out of the 261, the Auditor General has only 63 offices. And the 63 offices, Mr. Speaker, their presence is only in 63 districts. So they do what we call cluster, they cluster the districts. And they use vehicles and fuel to transport to most of these other districts that their presence is not there. If you go to a place like Bana, Wenchi, the office of the Auditor General is in Wenchi. So they move from Wenchi to Nsoko every day to come and audit and go back. They move from Wenchi to Bana every day to come and audit and go back. Mr. Speaker, consider the fuel cost. Put that one aside. Consider the hotel accommodation.
Put that one aside. Auditing has become so expensive. And based on this, Mr. Speaker, I want to plead that this House, since the Auditor General is a part of office, Parliament of the Republic, we must make sure that we assist the Auditor General to have his presence in all the 261 district assemblies. And the district chief executives, together with the assembly members, must make sure that they provide office accommodation for the Auditor General, at least in every office. It will save us the fuel cost, it will save us the hotel cost, it will save us the risk in transporting staff from the 3 district capitals to the other district every day. Even the 63 district offices, 30 of them, Mr. Speaker, are rented. So by implication, the Auditor General can boast of only 30 offices in 30 districts. Mr. Speaker, then we said, oh, we are becoming corrupt. Why we will not be corrupt? The presence of the Auditor General in every district can scare would-be corrupt people from being corrupt. And Mr. Speaker, we must do this. We must not be interested in building other offices, building anti-corruption institutions only in Accra. We need their presence in every district. No matter how small it will be, this will go a long way, Mr. Speaker, to help us. Other than this, we will keep on thinking that we are fighting corruption. By the time we realize corruption has fought us and scored us, then we'll be living in the glorious days that we are Ghana Blaster. We won the African Cup 4 times. Since when? We cannot be relying on past glory. We must strengthen independent constitutional bodies, anti-corruption agencies, to make sure that they watch us. That's because when you are being watched, you yourself, you look sharp. So thank you for the opportunity, and I urge everybody, all of us in this House, to approve this motion. Thank you, Mr. Speaker, for the opportunity.
Very well. Honourable members. Yes, leader.
Mr. Speaker, the member for Buem made a point about a deficit in the discharge of the responsibilities of the audit service, that they didn't have enough money to visit foreign embassies to audit the accounts of the embassies. I appreciate the point. But Mr. Speaker, I keep saying that what the audit service does is at the expiry of the financial year, the committees of parliament charged with the responsibility, what do? You are not lamenting the status of your own committee. I appreciate the point that you have made, but I'm just telling you that, like a sympathizer, you are weeping more than the bereaved. You are here. Your own committee is supposed to do that function, perform that function first, before the audit service will follow after a year after the deed has been performed. Our own committees are not doing that. That's my worry. So I'm not disagreeing with the committee's report. I'm just saying that we should remove the speck in our eyes before we attempt to remove the beam in the eyes of others. Let's live up to our responsibilities, our own charges, before we sympathize with others. Mr. Speaker, I think it was yesterday that we were relating to this issue of what to do with establishing the appropriate committee after the auditors have submitted their reports to us, and via the Public Accounts Committee for such reports to be debated in the House. Mr. Speaker, let me reiterate the point that I made yesterday, that the House should come together to constitute this committee before we adjourn on the 22nd of this month. And also to insist that, because there's some disagreement between Parliament and the Auditor General, the Auditor General seems to think that he is a man of himself. Constitution does not allow him to do that. He's a tool of Parliament in the discharge of our oversight responsibilities. They must report to us first. Before they go to public, they go public and expose the reports that ensue from their own investigations. It should come to Parliament first. How many occasions have they not come before the Public Accounts Committee and rendered apology to people that they have already scandalized? The Constitution enjoins them to submit their reports to Parliament. Until they do that, their work is not complete. I think the Auditor General should understand that. They seem to think that they have their own sovereignty and they can do as they please. There's some restriction imposed on them by the Constitution, and they should respect that. Mr. Speaker, thank you.
Honourable members, at the conclusion of the debate, the question is as many as are in favour of the motion in the order paper addendum 2, say aye. All those against, say no. Honourable members, the ayes have it. The motion listed in order paper addendum 2 is hereby adopted, and that this honourable House approve the sum of 633,740,507 Ghana cedis for the services of the audit service for the year ending 31st December 2024. Yes, Leader.
Speaker, I think we are done for today. The reports that we laid, we have done justice with them. And so many of them listed for today, which have not been presented to the House. So, Mr. Speaker, I will appeal to the various committees, those of them that are still considering their reports, to finish with them and submit them to this House early morning tomorrow. If you have them sufficiently laid early enough, then, Mr. Speaker, I believe if we allow ourselves about an hour or so, we can begin to do the consideration of those reports. Because for now, we have about exhausted the ones that were presented, courtesy of the Special Budget Committee. Mr. Speaker, I lead by example. So, the 8 reports that we have dealt with today have almost all of them, apart from one, that came from Constitutional and Legal Affairs, 2 of them. The other 6 have all come from the Special Budget Committee. So, Mr. Speaker, I want to reiterate my appeal to the other committees. They should submit their reports early tomorrow morning for presentation to the House. We can accord ourselves little time and thereafter go into the approval processes. Mr. Speaker, thank you.
Yes.
Mr. Speaker, the table of issues liaise with the leader so that we know those reports which were supposed to be distributed and not done. Yes. Yeah. So the clerk at table should give to me and Lydia so that we put it on the caucus platform, because we can't come here tomorrow and same thing will be repeated. I know the members, the chairman and the ranking members will own up. Then we can expedite action. So that's what I want to say.
Very well. On that note, honourable members, we will move to adjourn the House to tomorrow, 10 o'clock in the forenoon. I think we have to thank ourselves. We've done well for the day. And
we have to thank you, right on, Speaker.
We have to thank all of us. We have to thank ourselves. Yes, Leader.
Mr. Speaker, the Honourable Amakufibwa is a deputy minority leader. Mr. Speaker, there is only one right Honourable Speaker. The other deputy speakers are Honourable Speakers. Thank you very much.
Mr. Speaker, just the finance minister must hear, and the deputies must hear, and the minister of finance and the minister of finance must hear that we've done all this, and they must take the sentiment of the house along. Thank you, Mr. Speaker.
On that note, the House is accordingly adjourned to tomorrow 10 o'clock in the forenoon. The House stands adjourned.